Thank you very much. Welcome, everyone, to this public hearing. It is focused this evening on taking public testimony. By our counts, most recent count, we have roughly 54, maybe 55 signed up, which suggests something approximating 3 hours if each individual either cedes their full 3 minutes to somebody else or uses their full 3 minutes. So again, we'll need to be efficient to get us out before my bedtime anyway. And I understand that there are some supplemental written materials that some of you may have to support your oral testimony. If you do have such and copies for everyone, please be sure that you check in with Ms. Kwiatkowski in the floral print. She is our recorder, and that will ensure that it gets entered into the written record. And obviously, we won't be able to read it simultaneously with your oral testimony, but we will have it in our hands. So with that, I get to read a bunch of things again. Many of you could probably recite this from memory by now. This is the time and place for the continued public hearing in the matter of LU-24-027. The subject of this continued public hearing is an application for a conditional use permit to expand an existing landfill. The applicant is Republic Services and the property owner is Valley Landfills. Oregon law requires that I make several preliminary announcements for this hearing. This is a continuation of the quasi-judicial hearings previously held on April 29th, May 1st, May 6th, May 8th, and July 8th, and it will be conducted pursuant to Benton County Development Code sections 51.705 through 51.725. The purpose of the continued hearing is for persons to present and rebut new evidence and arguments not previously presented to the Commission. Evidence means facts, documents, data, or other information offered to demonstrate compliance or non-compliance with the standards relevant to the decision. Argument means assertions and analysis regarding the satisfaction or violation of legal standards or policy relevant to a decision. Argument does not include facts. In a quasi-judicial proceeding such as this, it is the Commission's duty to apply the law, not revise it. The Commission must determine whether the applicant has met all of the applicable criteria in the Benton County Development Code. The Commission will consider the record as presented and will also consider any new evidence or argument that is submitted into the record. Please do not communicate verbally or in writing with any commissioners outside of this hearing process. A supplemental staff report has been prepared for this application, and the supplemental staff report was available 13 days before tonight's hearing. The supplemental staff report identifies the approval criteria that apply to the applicant's proposed development and analyzes those criteria along with new evidence submitted during and after the initial public hearings. Evidence and argument presented during these continued public hearings should be directed toward the new evidence included in or described or evaluated in the supplemental staff report and the applicant's new materials. Any person may present or rebut any new written evidence, arguments, or testimony while the public record is open on the application. Any written materials received by the county staff during the time period in which the record is open will be placed in the record. Written materials submitted during the public hearing must be presented to the county staff in order to become part of the record. Except planning staff and the applicant, no screen presentations are allowed. If a person intends oversized poster boards, reports, or pictures used in their oral testimony to be placed in the record, copies must be submitted to county staff while the record is open. If they are not given to staff, they will not be included in the record. Question to the planning commissioners. Does any member of the commission wish to declare an ex parte contact since yesterday evening? I will now go through the hearing procedure for tonight. The procedure is as follows. We've already heard the revised staff report presented by the staff planners. The applicant has presented its case in support of the application. We'll then go to testimony from proponents of the application limited to 3 minutes per person. Then testimony from opponents of the application also limited to 3 minutes. Finally, the applicant's rebuttal. The commissioners may ask questions of persons providing testimony. However, the purpose of the public testimony is to provide information for the commissioners to consider. The public is not permitted to ask questions of the staff, the applicant, or the commissioners. Prior to the conclusion of the continued hearing, any person may request that the record be left open for 7 days for the limited purpose of responding in writing to new evidence submitted at this continued hearing. Following applicant's rebuttal, I will ask whether any person requests that the record be left open for this limited purpose of responding to the new written evidence submitted at this continued hearing. Upon such a request, the Commission will determine whether new written evidence was submitted at the continued hearing, and if it concludes that it was, the Commission will leave the record open for 7 days for the limited purpose of responding to the new written evidence submitted at the continued hearing. If there is no request for an open record period, the record will be closed and the applicant will be entitled to submit final written argument prior to the Commission's deliberations. If you are a participant in this hearing, the Commission expects you to abide by the following rules. All testimony and evidence must be directed toward the applicable criteria in the Benton County Development Code or other criteria which the person believes applies to the decision. Please be respectful of all participants, both when you are speaking and when you are not speaking. Speak only in the order of the proceedings or when recognized by the chair. In testifying, please do not repeat previous testimony made at the previous hearings. Be advised the chair may halt testimony if it has become irrelevant, abusive, or clearly intended to harass or intimidate the participants in this hearing. Verbal testimony is limited to 3 minutes total per person. Please respect these time limits so others have the opportunity to testify. Any written exhibits you want included in the record need to be handed to the Commission's recorder for marking prior to being presented to the Commission for consideration. Any multimedia testimony is considered written testimony and should be submitted in the same manner as written testimony. To have standing to appeal the decision of the Planning Commission, you must present oral or written testimony to the Planning Commission prior to the closing of the record. Failure to raise an issue in this continued hearing accompanied by statements or evidence sufficient to afford the Commission an opportunity to respond precludes appeal to LUBA, the Land Use Board of Appeals, on that issue. The failure to raise constitutional or other issues relating to the proposed conditions of approval with sufficient specificity to allow the Commission to respond precludes any action for damages in circuit court. The continued public hearing is now open, and I realize I did not take a roll call.
I was just about to ask about that.
So I need to rewind and take a roll call. Commissioner Bisco.
I am present, Chair Fowler. Oh,
Yep, we heard you. Thank you.
thank
Commissioner
you.
Cash.
Here.
Commissioner Fulford.
Here.
Commissioner Lee.
Here.
Commissioner Struthers.
Here.
Commissioner Wilson.
Here.
Vice Chair Heyman. He was going to participate potentially virtually as he logged in. Don't see him, but I will note for the record that we do have a valid quorum. Okay, so we will begin with testimony from proponents of the application. And if you participated in our May's public hearing, you kind of understand the process. We have an on-deck area for the person waiting their chance to testify. I'll call out the current person and the name of the person to go on deck. So beginning with Ms. Brewer, you are next with Mr. Simpkins on deck. Please begin.
Good evening. I appreciate this opportunity to address the Planning Commission. I'm Linda Brewer, a Benton County resident of 38 years and a certified professional soil scientist. I'm here to speak in favor of the expansion of Coffin Butte Landfill. I served for more than 10 years on the Benton County Solid Waste Advisory Council. In addition, I have lived and worked in the developing world in a city of 2 million without a waste management plan. Many of my neighbors do not value the landfill resource we have in Benton County. They are seemingly unaware that Coffin Butte Landfill is not our landfill, but rather was designated as a regional landfill more than 50 years ago. Nor are they aware that trash originating in Benton County receives a preferred tipping rate at the landfill. I expect to see the cost of trash services in Benton County to double or triple when the waste stream currently going into Coffin Butte is hauled out the Columbia Gorge to Arlington and that preferred rate disappears. This gives rise to at least 3 concerns. First, county residents who cannot or will not afford the increased waste management fees. We can expect to see more illegal dumping and a tax increase to go along with that for cleanup. There's the concern of the inevitable litter loading of the scenic gorge. Also, the increased carbon footprint of Benton County trash. At this time, the Republic fleet clocks in about 1 million miles in Lynn and Benton County for waste each year, waste and hauling. Each round trip to Arlington adds about 450 miles to that footprint. I would like to redress a falsehood which has been repeated throughout this process. I have reviewed 10 years of groundwater quality reports of samples collected from under the landfill and seen a downward trend in compounds of concern. The landfill is sited in a very difficult climate, and the management by Republic Services has been commensurate with the challenges here. The landfill was not a hidden flaw of the properties purchased by the original complainants at the time of purchase. The site has been a landfill since before World War II. These landowners have benefited from reduced property taxes for years. What I don't hear from them is a commitment to change their standards of living so as to reduce their environmental footprint. I am encouraged to understand that the county has developed a list of conditions under which the landfill may be expanded rather than acceding to the NIMBY demands of 2 years ago that the landfill be closed immediately. Thank you.
Thank you, Ms. Brewer. Mr. Simpkins. And Mr. Gelatly is on deck. And again, I will apologize, as I did in May. I am very likely to butcher some names. So I am apologizing for my pronunciation of names. Mr. Simpkins.
Good evening. My name is John Simpkins, and I've lived at 5812 Northwest Dumbeck Avenue for 26 years. Our property is 3.86 line of sight. Hello. Okay, sorry about that. I've lived at 5812 Northwest Dumbeck Avenue for 26 years. My property is 3.86 line of sight miles from the top of cell 5 in an east-southeast direction. I've served on SWAC for 16 years, 2006 through 2021, and then was term limited out. SWAC supported the 2021 CUP. I'm here tonight to strongly support the current CUP. This is due in part to the extensive infrastructure and operational improvements undertaken at the landfill since Republic Services acquired Coffin Butte in 2008, and those improvements have directly improved my life at my property. Much of the public testimony given during the 2 CUP applications has been in opposition. Citations include fugitive emissions, noise, traffic, groundwater impacts, wildlife impacts, and litter, etc. However, these complaints actually strike to the very existence of the landfill itself rather than specifically pertain to either of the landfill expansion procedures. 2 of the fundamental questions that the Planning Commission and ultimately the Board of Commissioners must address are, One, does Benton County want to continue to host a landfill within the county boundaries? Two, does Benton County believe that it has the power to force Republic Services to retain Coffin Butte past the point of economic viability? If the county government believes that the landfill's benefits outweigh its detriments, then it must take the politically unpalatable choice to support Republic Services in keeping the landfill open for as long as possible. Conversely, if the county government believes that the landfill's detriments outweigh its benefits, then it must make the economically and technologically unpalatable choice to permanently close the landfill and begin sending its waste to Central Oregon as soon as possible. Again, I strongly support this CUP. Thank you.
Thank you, Mr. Simpkins. Next is Mr. Gilatly.
So when I went to register, I found that there was no neutral button. And what that leads to is that if you have a neutral position, or one that really encompasses the views of everybody in the room, it's hard to put up a neutral thing. So I did choose, at actually the recommendation and conversation with county staff, to be a proponent. And I hope you'll believe that I'm acting to do that in a way that, so it may take me a bit more than my 3 minutes, but I beg your a bit of an indulgence here. The only witness I would like to really have be here is my grandfather. He knows this county. One of his sons, by the way, is going to enter into my story here. With that, I would like to proceed and let timer start. And I beg your indulgence as necessary. I'm Bill Galatly. My address is 2923 Northwest 13th Place. And that's just north of Walnut, up right above the three churches, so that you can get a real pinpoint on it. It's almost.
Mr. Galatly,
Yes.
Mr. Galatly, could you please focus your comments towards the
I'm
planning
sorry.
commission?
I will certainly try to do that. I want to be as inclusive of everyone. I'll do that. After 10 years of consulting, I had to figure out what were the most important things that could make a difference here tonight. And part of it came from a guy who encouraged me to open my own consulting business after 37 years in the corporate world and 6 years working with Habitat for Humanity. What do I need to know? And is there anything in what I know that can help? And the best example, we might start now, we'll get right into the matter here. What's the weather like at Coffin Butte? Primary thing you need to know is that the weather at Coffin Butte contains 38% more rainfall than you get at Corvallis Airport. That's 50 over 36. Those are the two. Everybody knows those rainfall numbers. And initially, I didn't know that there were two kinds of substances that were at Coffin Butte. And so I had to talk to some specialists. And on page 4, I believe it is, of my testimony, which I hope you have copies of now, you'll find a list of experts that I talked to. And I put together an informal team of people because I don't know enough about this stuff, but I found people that do. What I was starting to mention about some of the chemicals is we've got some that are considered hazardous. They're medically untested. And we have a number of regulated chemicals. You're all very familiar with those, how those balance out. I'm a Pareto guy, so instead of worrying about the 67 compounds that are in the FOIA request from the city testing of water coming out of the processing plant, I focused on what are the top concentrations? What do they represent in the volume of this little cube we call a liter, and how many nanograms or micrograms are in there? And I said, you probably ought to start with the one that has 41,000 parts per minute. Oh, no, excuse me, I got that a speed thing, didn't I? What I wanted to say was 41,000 nanograms per liter. I know my time is up, and I will get to my point when we check it here.
Yeah, and we do need to respect the other speakers this evening,
Yes,
so if you could get to your
I
point.
do understand that. And I'm going to just mention that if you want to understand the geology of an area, it's really important to not only get people who are qualified in the field, but if you want to get the equivalent of microclimate information, you ought to talk to a well driller. One of my well drillers' names, my cousin has, a well driller has his name on probably more wells than any other in this county. If you want
Mr.
to- yes.
Mr. Galatly, we do have to move on.
All right.
So
I'd
we
like-
we do
let me-
have your
I'll
written,
give you my conclusions here.
please.
I'm asking the county to consider a 10-year plan that may start now or sometime in another few years that ceases the use of the landfill and that will assure the least risk based on all the unknowns of the PFAS chemicals, which come out in larger numbers here because of the amount of rainfall. And the difference in rainfall between here and Arlington, everyone knows, is really dramatic. The transportation costs that are being compared, respectfully, do not include sensible and best use of rails. So I would ask that a rail facility be put in to avert traffic on 99. I have one more quick point I'd like to make.
I'm very sorry. We have to respect the other
All
speakers
right?
and
With
their
that,
time.
I would invite any questions.
Well, I very much appreciate your testimony and also that we have written copies of it so we can consider it offline. So
I will assure you that I'll answer my phone and be glad to talk with any of you in more detail at any time.
thank you very much, Mr. Galatly. We will now move to the testimony from opponents of the application. And first, speaking in opposition is Mr. Crockett, who I understand from my sheet is ceding his time to, and I hope to get it right this time, Mr. Geyer. Oh, I have it. Okay, thank you. And if you could remind us, Mr. Geyer, whose time you are using in addition to Mr. Crockett's?
Yeah, so it's Joe Crockett, who's number 1 on the list, I think, and then number 19 is Rose Holdorf, and number 20, Janet Oman. Thanks, Rose, Joe, and Janet. Yeah, so should I start? Go ahead and start. Okay. Yeah, so I'm going to start my own little timer here. I use it for bird counts because that way, hopefully, this will remind me before I get past my time. Yeah, good evening, Chair and members of the Plan Commission. My name is Joel Geyer. My address is 38566 Highway 99W, Corvallis 97330. Thank you for yet another opportunity to provide new information on this application. I've mentioned the people who ceded their time, and thank you again. Someone told me I should say a little more about my qualifications. I came from a working class farming background. I don't like to toot my own horn that much, but I do work as an internationally recognized expert on the topic of fractured rock hydrogeology. In other words, in simpler terms, groundwater flowing through cracks. I've listed a few recent projects in my testimony, written testimony, which is I've submitted separately if you want to take a look at that. Tonight, I'll speak on 4 topics where we have new information. First, groundwater impacts, including arsenic. Second, PFAS impacts on rivers. Third, the applicant's explanation of why they're so slow to close completed cells. Sorry, that's a tongue twister. I shouldn't have put it on here. Why they're so slow to close completed cells. And finally, wildlife, including herons. But before I get rolling here, I'd like to thank Commissioner Struthers for being on the ball last night and noting that the Corvallis drinking water plant is actually upstream of the wastewater treatment plant. That was super helpful information for the discussion. It's good to have a city councilor that shows up for these things. Former, yeah. Yeah, you can't do two hats at once. I'd also like to thank Mr. Winterroad. I don't think he's here tonight, but I appreciated that he said out loud that this is a new landfill. It might have been a slip of the tongue, but it has the ring of truth. And it does raise a significant question for you as commissioners. Do you know for sure if Oregon DEQ will treat this as an expansion, as it's titled, or will they treat it as a brand new landfill? Has anyone asked DEQ? There is a precedent in Baker County where DEQ has agreed to treat two landfill units separated only by a road, as in this case, as separate landfills for regulatory purposes, specifically for monitoring methane. Mr. Winterroad also expressed surprise that most of the comments on this application came from areas south of the landfill site. This is a little less surprising if you know that the county staff unfortunately did very little to inform Polk County residents. Despite all of the good talk that came out of the BCT process about notifying residents for 5 or 10 miles in all directions, it seems this didn't really happen. Public notice was only placed in the Corvallis paper, not the Polk County Itemizer Observer or the Salem Statesman Journal. So people in Monmouth and Independence were notified, Airlie and Suver and so on. The lesson is members of the public are only likely to participate if they're invited to participate. Benton County unfortunately forgot to invite our neighbors to the north, even though many of them live closer to the landfill than where we're meeting tonight. Regarding groundwater, I'll try to be really brief here. It's not exactly rocket science, but it's not tiddlywinks either. I've submitted my technical comments in written form. The applicant has provided new arguments on groundwater, but not much in the way of new data. What they have done is to plot old data in ways that tend to obfuscate the issues of concern. On the issue of how construction of the new landfill could impact wells on nearby farms and residential properties, they've really tossed you a red herring with this business about limited radius of blast-induced fractures. That led to a whole lot of discussion last night, very little of which has to do with the real concerns. No one is seriously thinking that a blast is going to cause a fracture to run a quarter mile through the bedrock. There is concern that seismic waves from blasting could rattle windows. There's a resident on the north side of Coffin Butte who has reported damage to concrete slabs on an outbuilding, which he believes were the result of blasting in the Coffin Butte quarry. Such things aren't unheard of around mining operations. But the real question is whether, in the process of excavating this huge hole on the north end of Tampico Ridge, Republic will cut into a water-bearing fracture zone that is also tapped into nearby wells. Groundwater flow in fractured rock isn't uniform, like what a hydrologist likes to call a porous medium. From decades of research, we know that it's more like a network of pipes in the ground. Imagine that you're out in your backyard digging a hole just for the fun of it, and you slice through a rusty old pipe that you didn't know was there. If that pipe is connected to someone's faucet down the block, they're going to have problems. Well, you might have some problems too, but no worry, you have a drainage plan. They're not going to be too impressed if you say, well, you're open to discussions about how to fix the problem, at least if they can prove that you caused it. These are the types of issues that people on Tampico Ridge are worried about. Yes, there are some fancier things that could happen if seismic waves cause fractures to slip and so on. I go into those a little bit in my written testimony, but really the realistic risks aren't that fancy. Turning to arsenic, it seems that the applicant really wants to make this question go away. They even went to the effort to try to cast doubts on the U.S. Geological Survey study, Hinkle and Poulette, that shows that naturally occurring arsenic is very rare in wells in the Mid-Willamette Valley. I printed out a map. I don't know if you folks wound up with this yet. Okay, excellent. It's on the first page of your packet. I'm sorry, it's small, but each of those red or black symbols on the map is where they did have data. They did admit there were large areas where data were sparse, but where high arsenic might occur. VLI's consultants seized on this thread as if it undercut the main conclusions. But look at the map. Those areas with sparse data are mainly in the blue shaded areas, which are up in the Cascades of Lane and Lynn counties. Maybe also a bit out in the Coast Range, but they had plenty of data from our area. I counted 50 wells that they sampled from within a 10-mile radius of Coffin Butte. That's a lot. VLI's consultants also seized on the idea that arsenic could come out of volcanic rock. But Hinkle and Poulet didn't say just any volcanic rock. They said rock of rhyolitic to intermediate composition. I know that sounds like Greek if you're not a rock hound, but as volcanic rocks go, rhyolite is the opposite of basalt. Hinkle and Poulet specifically stated that basalt is unlikely to be a source of arsenic. The volcanic rocks on Coffin Butte are mainly basalts, not rhyolite. So that argument fizzles. Another red herring. If county staff had independent geological experts who could help them to review the applicant's latest filings, they could have flagged that red herring right at the get-go. That might have saved us some time last night. The county did have a couple of experts like that right under their noses, but they didn't make use of them. I'm pretty sure Tony Sperling knows the difference between basalt and rhyolite, and so does Dave Livesey, currently serving on DSAC. But the county missed that opportunity to tap into their expertise, and that makes your jobs, unfortunately, a little bit harder. I also have my second little sheet here is sort of hot off the press. The second page is Riverkeeper has just reduced a study on PFAS downstream of wastewater treatment plants. And what I'd like you to see in there is that the Rock Creek, the Tualatin River comes up as a site. They didn't look at anything on the Willamette River, but the Tualatin River, there's the Rock Creek water treatment site in Hillsborough, which accepts landfill waste from their own Hillsborough landfill and until recently, at least, from the Riverbend landfill. It shows up as one of the 10 worst sites in the nation out of those that were tested in terms of having PFAS show up just downstream of the water treatment plant. Upstream clean, downstream lots of PFAS. My third topic is something that was let slip on day 4 of this hearing, which shed light, the applicant let slip, perhaps inadvertently, and I think it might have shed some light on their intentions regarding Coffin Butte Road. At the 2:33 mark of that hearing, Commissioner Biscoe raised the question, has there been any reclamation that occurred on any of the cells 1 through 5? Mr. Roop responded, no, those aren't final capped yet. Commissioner Biscoe repeated the question and Mr. Roop deferred to Brent Lurch, Republic's area environmental manager. Mr. Lurch gave a long answer, which you can review in the transcript, but here's an abbreviated version. As far as reclamation, really you don't go into post-closure until everything is final closed and it's not an active facility. One thing we do want to make sure prior to that is that we have hit our final grades and we're at a point where we don't have to ruin that area if we had additional operations. Let that sink in. We don't have to ruin that area if we had additional operations. Additional operations in this business means piling on more garbage. As long as they haven't started the final closure process, they're still keeping the door open for more expansions in the adjoining airspace. Elsewhere in the record of previously submitted evidence, you've learned of an email exchange between Republic's local representative, Julie Jackson, and County Council, which also pointed towards additional future expansions. In the application before you now, the applicant claims that they've scaled back their plans and no longer intend to pile garbage across the top of Coffin Butte Road. But Mr. Lurch's comment makes it clear that they're still keeping the door open. This is why Benton County residents up to 5 miles away have to look out on the visual blight of a mountain of tarps every day because the company doesn't want to ruin that area for additional operations. Approval of this permit would not just add visual blight from the new smaller landfill, it would virtually ensure that the visual blight of the existing landfill is extended indefinitely. And it creates a loophole by which Coffin Butte Road could be closed in the future without any need to consult you as the Planning Commission. Please don't fall for this ruse. Denying this application is the only way to prevent indefinite expansions that bring further adverse impacts on the community. And lastly, I'd like to say a few words about great blue herons. One of the big concerns in 2021 was that the expansion scheme, by changing the topography, would block a flyway currently used by herons to travel from their nests to foraging areas in the upper Soap Creek Valley. That is still a risk. VLI's wildlife consultant has recently acknowledged that the herons are still nesting close to the development area in a grove of Oregon ash trees just across the highway. They now suggest that the herons might be better off in the new location, in part because, I'll quote, the new rookery location is in a mixed conifer deciduous stand farther from landfill operations. Okay, I can believe that the landfill operations are in fact a threat and proximity is a problem, but there's not a single canopy forming conifer in that stand. It's nearly a pure stand of Oregon ash with a few odd cottonwoods. You might have heard of the emerald ash borer. This is an invasive species which is a major threat to trees in our region, particularly Oregon ash. There's no type of tree more in peril. So yes, the herons might need to recolonize the poplars where they nested successfully for many years up until the odd events of 2022. I was planning to comment on one more issue, which was the staff's idea to run a chain link fence all the way around forest conservation lands. But I was happy actually to hear from Mr. Condit that he and I agree on one thing. This is a bad idea and that would impact wildlife. And thank you for your attention, and I'll be happy to answer any questions.
Commissioner Lee.
Thank you. I got confused about your discussion of arsenic in basalt versus rhyolite. Where does the arsenic come out of most? Basalt versus rhyolite?
Yeah, the Hinkle and Paulette, they determined that it came mostly from, it could all be attributed to formations with rhyolite, not from basalt. And they also cited other past work by other scientists who had shown that arsenic was very unlikely to come out of basalt. Where it does occur in combination with basalt in some places in the South Willamette Valley, it can be shown that those areas probably are drawing water from rhyolitic formation. So rhyolite is the source. Specifically, they talked about glass, like you remember obsidian, so in rhyolite.
So the basalt around, or the rocks around Coffin Butte, are they basalt or are they rhyolite?
Yeah, the rocks at Coffin Butte are basalt. So they're
So-
not the type of rocks where, at least according to this USGS study, you would expect arsenic to come out of the rocks.
So therefore, if you're saying it's more likely that any arsenic being detected in wells is coming from the landfill rather than the deterioration or the oxidation or whatever of the basalt.
Yeah, I think what I would say as a scientist on this issue is that we don't really know what's going on with arsenic there, and I don't think the applicant knows. It's the explanation they've offered doesn't hold water, and I really think it should be investigated more thoroughly. There are options to do that, and that's what I think should be done. But I personally don't think that it's credible that it's coming out of the salt.
So another question I had was regarding the fractured rock, because I live in an area where the geology has fractured marine sediment, not fractured basalt. And we got a whole bunch of training on, why our wells behave the way they do. And the fractures are random, unpredictable. And yet this report uses the word that there's something, I can't remember. It gave the impression that the fractures are predictable or homogeneous or some sort of not the same as in fractured marine sediment. But can you talk about that for a second?
Yeah, they didn't quite go that far. What they said was that they were just going to assume that even though they don't really know where all the fractures are and how they're distributed and how they're connected, they were going to assume they were all connected. And if all the fractures are connected sort of everywhere, you end up with something that's kind of more like sandstone or something that where water flows more regularly through it. They said that was a conservative assumption, but it's not necessarily conservative for people who have worked in this type of rock. So, but they actually, what they did is sort of a common thing that people try to do when they're trying to deal with fractured rock without having very complicated models. But it's, yeah.
Thank you.
I see that Commissioner Bisco has a question.
Thank you, Chair Fowler. Can you hear me?
Yes.
Very good. Mr. Geyer, thank you for your testimony. This is Commissioner Bisco attending virtually this evening. I just was curious, you referenced a landfill example, I believe it was in Baker County, where a road actually served as a division towards what DEQ then recognized as two separate landfills. I think I'm paraphrasing that. Do you have that information in your written testimony that you are submitting this evening as a reference beyond what you shared with us in your verbal testimony?
Yeah, unfortunately, I don't have that in my written testimony. It came up during the discussion of Senate Bill 726, and it turned out that DEQ had given special consideration to Baker County for their, I think it's the Baker County, I don't know if it's a municipal landfill or county landfill, allowing them to treat those two landfills separately in terms of methane emissions and not let them get out from under some criteria for the type of monitoring they have to do. It's a matter of state record, but not on this record, I don't think.
And again, that was House Bill or Senate Bill
726, SB 726.
SB 726. This 2025 legislative session, correct?
Yeah, that's right. And I don't know, it's not referenced, this isn't referenced in the bill, but it came up in the discussions around this bill.
Very good. Thank you, Mr. Geyer, for your very lot of information you provided. Thank you. I have
Commissioner,
nothing further. Excuse me, Chair Fowler.
Thank you, Chair Fowler. Thank you, Mr. Geyer. Again, I didn't hear well enough tonight. What do the colored dots represent on the map that you submitted?
Yeah, those, they're, I'm sure it's supposed to be printed on like double the size of
I
page.
absolutely understand.
So the black dots are wells that had arsenic readings that were under 10 micrograms per liter, or you can think of it as parts per billion, I think. The red dots are wells that had, if they're hollow red dots, they are wells that had between 10 and 50 micrograms per liter. If they're solid red dots, that's the bad stuff. That's where it's over 50 micrograms per liter, which has occurred at least temporarily at Coffin Butte, but otherwise it's really only seen, for instance, up by Sodaville. Yeah, so.
And I don't believe that I have Mr. Geyer's written testimony. I don't know if other commissioners do.
Yeah, I just turned it in here. I've been working on it all day.
What does it look like on the front or?
well, it has not been.
Oh, we
passed out.
don't have the written one. Okay.
No, it is posted to the document system that we have access to. Commissioner Struthers. Oh, I see. Commissioner Wilson.
Thank you, Chair Fowler. Mr. Geyer, thank you for your testimony tonight. Last night, I asked the applicant about the disturbances that would occur in the blasting in the new site. And I guess there are two things happening here. One is that the applicant has presented that they believe they know the water flows on the Tampico Ridge. But what I'm curious about is that in your discussion about the rock formation there, would it be safe to say that any disturbance at the new site, either with blasting or removal of material, would impact the water that is flowing through Tampico Ridge, and that it could increase the levels of pollution of whatever kind, arsenic or other contaminants that may exist in that site?
Yeah, I wouldn't agree that they know the water flow under Tampico Ridge. What they've done is they've taken a map and they've drawn arrows to show the downhill direction, basically, which is how water would run off the ridge, but not how water would move through the ridge. Big difference. I did submit a paper earlier in written testimony, which describes a study of the Oak Creek watershed, which gets into some of this issue in detail. The investigators there, who are based at OSU, found that the flows in the Oak Creek watershed, which is very similar to what we have just north of here, did not conform with the type of simple picture that you've seen in the application.
And to the second part, that any disturbance or removal of materials, would it substantially impact those water flows and the contaminants that could be released in that process?
Oh yeah, sorry, I didn't get back to that. I think the biggest issue is actually that the disturbance of removal of materials is going to sort of create a drainage place where water can drain to out of the ridge. We're more worried about water contaminants moving in the other direction, actually, which is more downhill and towards the valley.
Okay, thank you. Thank you, Chair Fowler.
Thank you, Mr. Geyer. Appreciate it. Next up is Mr. Kleinman. And I've got some notes that you are also using some time seated by others. And so if Mr. Kleinman, you could He's virtual, okay. If you could articulate whose time you are using in addition to your own.
Uh, Thank you, Chair Fowler. Jeff Kleinman for Valley Neighborhood for Environmental Quality and Safety. The time that was yielded to me was from Ken Edwardson, Kent Fields, Mary Braun, and Carol McClelland Fields.
Please proceed.
Thank you very much. Thank you, Chair and members of the commission. My name is Jeff Kleinman. Really appreciate the opportunity to testify, and having watched the proceeding last night, and I say this not to flatter, but I admire your endurance. In watching that proceeding, I really thought I had seen a performance by Cirque du Soleil. It was beautifully orchestrated and coordinated with an armada of consultants, all aiming to get this commission to yes. Having been before your predecessor commission on Republic's application in 2021, and having observed the county's process since, I would say that all the intervening machinations have been intended by Republic and its county advocates to the same end. In other words, getting to yes. First, we saw the extended and very expensive BCTT process that a lot of folks put a lot of time into, and that did not get the applicant or the county where they wanted to be. And as I've said, the resulting recommendations aren't binding on the Planning Commission in any event. Next, we had the elimination by the Board of County Commissioners of that darned pesky SWAC, and the substitution of NRAC as a preliminary reviewing committee. Well, that didn't work out too well either. NRAC rebelled at the blinders placed upon its process by county officials, and it unloaded big time on this proposal. And now we're here. I know from my experience before the 2021 commission and before you this past spring that the commissioners actually read everything before deliberating. Very much appreciated. I have filed a memorandum with your staff and will not belabor you tonight with all the contents. Instead, I'll try to hit a few high points and touch on some of the questions that commission members asked last night. The major theme of the presentations last night from staff and the various consultants was that the application could not be approved in the spring because there were a few impacts insufficiently addressed by conditions of approval. But now we've got 85 conditions. Imagine that. So we're good. The problem is that under the law, those conditions do not serve to satisfy the applicant's burden of proof or achieve compliance with the county's approval standards. They do not serve as a restraint on Republic, but as more of a piñata for Republic to whack at now and then over the ensuing years. Under the law, as discussed in our memo, if present compliance with the approval standards is not proven, an applicant can try to prove that compliance would be feasible by means of imposed conditions. And what does feasibility mean in this context? The law requires that there must be substantial evidence supporting a finding that solutions to certain problems are possible, likely, and reasonably certain to succeed. And in almost every instance, that is not the case here. That has not been demonstrated on the record before you. Let's talk a little bit about the ostensible effort to resolve noise and odor impacts through conditions involving monitoring. Monitoring doesn't resolve anything unless the operation is required to shut down immediately in the event county standards are violated. Otherwise, what's the point? Monitoring is otherwise an idle act a fiction or fantasy of compliance achieving nothing whatsoever. The conditions imposing monitoring do not demonstrate the likelihood of achieving compliance. They only demonstrate that Republic itself will learn of its own violations, assuming that adequate parameters are applied. And guess what? They will already know they were in violation, so what's the point? Under no circumstances can compliance rely on county enforcement, whether now or 2 years from now, when the county may fund some sort of countywide code enforcement provision or position, or adopt new regulations, as was referred to by staff last night. I'm sorry to offend. I apologize for this, but at the same time, I mean it. If there is a single word to describe the county's position vis-a-vis this landfill, it's complicit. There is too much revenue at stake for the county to look in any other direction than away. The applicant and the site have a history, and you would think the applicant has cleaned up its act in the past 5 years or so with its pending applications. And in light of the testimony you've received from the community and will receive, is this really the best they can do when they're trying to minimize their impacts? And that is just with a 0.5 acre, 1/2 acre working phase right now, according to the testimony last night, directly north across Coffin Butte Road. That is highly relevant evidence. Excuse me. Let me say first, now the proposal is to take the working phase to the south toward all these properties within Benton County. And instead of having a 0.5 acre working phase, to have a multitude of consecutive 2 acre working phases. And they contend that that's a sort of mitigation or control. So we have cited one of the stop the dump cases, the initial Luba case, and the subsequent Court of Appeals case in our memorandum to you. But what the case was cited for is that where you have an operating landfill and there is a proposal to extend or move part or all of the operation to a new location, in that case, it was also a bit to the south, then number one, the impacts of the existing operation are highly relevant and predictive of what they're going to be on the more affected properties to the south. And number two, you can use that evidence to determine the effects of the proposal. You don't get to ignore it, much less are you required to ignore it, as some folks said last night. I was somewhat dumbfounded by that assertion. There's been an effort, both with respect to the impacts on adjacent properties and with respect to the interference with the character of the area, to say that the existing operation to the north is somehow grandfathered in and it doesn't count. And it certainly counts as evidence of what happens on Republic's landfill. And now the movement to the south affects different properties more radically and changes the character of the area to the south. As we argue in our memorandum, if you're going to apply this grandfathering notion, basically, hey, we already ruined the character of the area, so what? They could continue to go south, south, south over the years without worrying about compliance, because as they move, they've already ruined the character of the next area. Doesn't work, but that's the assertion. There were questions from commissioners about the role of state agencies in assuring compliance. To the extent permits are required, that's one matter, And those need to be required to be obtained prior to the commencement of any operation on the site, including site preparation, because the blasting, et cetera, will have an awful lot of impact. But that is a totally separate question from the question of subsequent enforcement, because for all practical purposes, there is none and will be none, and let's not delude ourselves. Reliance upon state agency enforcement will not prove up the feasibility of compliance through conditions of approval, especially as the state does not deal with noise or odor in the first place. Enforcement is not the issue. Actual compliance is, and the applicant has not met its burden in this regard. There's nothing to enforce, and the folks who would enforce don't enforce, and you can't achieve compliance by non-enforcement. There seems to have been some confusion, and I touched on this a short while ago, or at least overlap in questions and answers last night about the applicant's past acts and omissions. I really want to emphasize this to you. This is not an enforcement proceeding which brings in, for past code violations that would implicate anybody's due process rights. If that were the case, you would have seen quite a bit of cross-examination last night, and I would have been happy to engage in it, but that's not the case. What you have before you is actual evidence of serious interference, impacts and effects, and explanations of how they will worsen if this application is approved. It is not, quote, anecdotes. That was a regrettably dismissive characterization. It is relevant evidence in every case, including this case. And I explained the role of that evidence in Stop the Dump. The county's conditional use criteria, especially as to noise, odor, and litter, are not objectively set government standards. Rather, they are plain English standards under Code Section 53215 sub 1. The proposed use does not seriously interfere with uses on adjacent property or with the character of the area. That's the standard, not some illusory, weird stinkola provisions that somebody came up with without even a means to travel and measure that odor at various affected properties. People smell the existing operation 9 miles away in Corvallis, okay? So the numerical standards do not get us there, and the code does not invoke them. Regardless of what Republic's sniffers detect under the conditions, for example, the question is the actual interference actually experienced by the actual owners or users of property. The evidence on that is compelling. It can't be sniffed or wished away or addressed at all by third-party monitoring of who knows what, by who knows whom, once a month. And if the operation in fact reeks in violation of the approval standard, there will be no way to mitigate that. So let me run through a few other considerations here. As to the movement of noise and odor, the actual evidence shows there is no way to account for variations in wind, temperature, humidity, and other atmospheric conditions. As to the noise control measures, let me really emphasize this. The proposed conditions address only the equipment operating for the applicant on the applicant's site. So the cats and related equipment moving fill around. There are no noise control measures imposed on the haul trucks, whether Republics or others, on or off the site. And so we have the motors, we have the brakes, we have the dumping, we have the slamming tailgates, and we have their horrendous backup beepers, proximity beepers, absolutely uncontrolled. And in addition, they contend that the years of blasting and site prep, roughly 4 years, are not part of the use, but they're wrong. As to the proposed fencing to prevent dispersal of litter, there is no evidence that this can or will succeed in containing lightweight wind-blown trash or trash blowing off of haul trucks on or off the site. That's simply not addressed. The applicant and its consultancy, many members of whom have just nibbled around the edges of the county's approval standards, have not sustained their burden of proof in this case. In the end, what can Republic say to the community? To use an old expression, who are you going to believe, our smooth-talking team of paid consultants or your own lion eyes, ears, and noses? Well, I know who people believe, and I know who this commission should believe, and I'd be happy to answer any questions you may have.
Mayor Wilson.
Thank you, Mr. Kleinman. Thank you for your testimony. And I guess if we were to summarize your position that you're representing yourself and the group, what was the name again?
Well, I'm not representing myself because I'm a lawyer. The group that I represent, many of whose members are before you, is Valley Neighbors for Environmental Quality and Safety. They were heavily involved in the 2021 case and were again activated in this case.
And so would it be, to summarize your testimony, would it be safe to say that you're finding that the 83 conditions of approval that the county has suggested as a condition of approval are not satisfactory to the consideration of the application? I don't know if I'm posing the question properly, but.
Well, I think you're very close. I mean, they do not achieve and will not achieve compliance with the county's approval standards. That's our position.
Thank you, Mr. Kleinman. Chair Fowler.
Thank you, Mr. Kleinman. The next person is Mr. Levitt. And I see some notes that he is also taking some time seated by Ms. Thacker and Ms. Castle. Is that correct?
That is correct. I also can quickly answer one of Commissioner Bisco's earlier questions regarding whether or not Baker's sanitary landfills information is in the record.
If you could put your mouth closer to the microphone, and if you want to incorporate that into your testimony, that's fine. It will be the same time limitations.
Okay. I will do that if I have time. I am happy to answer it also at the end. Chair Fowler, Vice Chair Heyman, and members of the Planning Commission, thank you for making time for members of the community to speak here again today, and we all appreciate your continued service through this thoroughly complex application. My name is Mason Levitt, and I am a GIS analyst and programs coordinator for Beyond Toxics, an environmental justice organization that works to address air, water, and soil quality concerns throughout the state of Oregon. We have worked with the residents of Soap Creek Valley and Adair Village for 3 years now regarding the operations of the applicant. I would like to speak to 2 items generally this evening. First, I wish to briefly raise novel concerns over the applicant's ability to meet CUP criteria for forest conservation zones. And second, I wish to respond to Republic Services' supplemental odor study and some of the discussion points raised last night, as well as the related conditions of approval. First, Benton County Code 60220B states that a CUP must be found that it will not significantly increase fire hazard or significantly increase fire suppression costs or significantly increase risk to fire suppression personnel in regards to CUP criteria for forest conservation zones. The findings and evidence in the record do not support that the proposed use will not significantly increase fire hazard or suppression costs and risks. The findings do not sufficiently address the Adair Rural Fire Protection District's recommendation to deny the application, including because the proposal may increase traffic and associated emergency response demands and present elevated fire risk, burdening the volunteer-based fire department. As discussed in detail last evening, Exhibit 20 is primarily based on landfill staff interviews, not a systematic review or record of fire events at the landfill site. The applicant's consultant stated last night that the landfill operators do not have and have not kept a record of site incidents related to fire. While this conditions of approval related to fire would require them to do so, that allows the operator to build the plane as they fly it. Benton County Code clearly states that they must show the new operations would not increase fire risk, and the applicant has stated they have failed to construct an accurate, complete, and representative database of fire incidents at the landfill. Now turning to odor. In May, I began my testimony with the quote, "All models are wrong, but some are useful." And today, I will begin with 2 quotes from the applicant's odor consultants. Quote, "Models are not great at modeling surfaces that have complex topography," end quote. They also stated, quote, "Models like this," in reference to AirMod, "are not such that they perfectly track what we measure," end quote. All 3 of these quotes nail a fundamental limitation of models. They do not reflect reality. Hence why the saying, "all models are wrong," and it is important to remember that tonight. Last night, both county staff and the applicant's consultant suggested the revised model is a substantial improvement from the first study, since it now demonstrates levels of hydrogen sulfide that would constitute a nuisance at the fence line of the applicant's property. I agree with their assessment that this is an improvement, but I would assert here tonight that the model still does not reflect what hundreds of residents in the Soap Creek Valley and Adair Village experience. You have seen and heard numerous testimonies that clearly demonstrate folks smell levels of landfill gas that constitute a nuisance up to 4 miles away from the fence line of the facility. This means that the applicant's model is still not an adequate reflection of reality and still does not meet the burden of proof that it is not a significant burden occurring on adjacent properties and ones further away. Remember, it is their burden of proof, and if they cannot prove that, then the application should be rejected. Recall the applicant's model is based on weather inputs, an assumed input of 930,000 tons of organic waste, and a fugitive emission rate of 25%. Based on third-party satellite data and ongoing investigations in the EPA, which have not been disputed, it is more than likely that Coffin Butte has an emission rate higher than 25%. In a hearing in late May on Coffin Butte's Title V air permit conducted by Oregon Department of Environmental Quality, DEQ outright stated that they do not have the expertise or staff capacity to evaluate if that 25% assumption is valid or invalid, even if they had tried specifically. The expertise to validate this assumption does not exist in the state of Oregon, and we have many reasons to doubt that assumption that the applicant has not disputed or responded to. Next, I would like to address the input rate of 930,000 tons of organic waste. Last night, the consultants hired by Benton County planning staff stated that the annual reports submitted to Oregon Department of Environmental Quality corroborate the applicant's assumption of 930,000 tons of organic waste. I have submitted tonight to the written record 3 of those annual reports. They do not distinguish between inorganic and organic waste intake. Instead, they distinguish between municipal solid waste and construction and demolition waste, as well as a few special projects. Based on the statements from planning staff and the applicant, it appears there was an equation of municipal solid waste and organic waste. However, the conditions of approval put forth by county staff and the applicant state that there ought to be a limit of 930,000 tons of organic waste as a condition of approval. I want to note that there was no clear definition put forth by the applicant of what constituted organic waste, and that seemed to differ from the earlier discussion of what constituted organic waste in the model's input. Second, in the same hearing for Title V air contamination discharge permit with Oregon Department of Environmental Quality I mentioned earlier, and in the planning documents submitted to Benton County, the applicant stated they estimate they will have an intake of 1.5 million tons of waste per year. Note, this contradicts what we had heard in May when the applicant stated they did not plan to increase waste intake beyond the 1.1 million ton limit. The applicant has offered no clarity on how they plan to document organic waste versus inorganic waste, and they have offered no explanation on how the 930,000 ton input for the model is corroborated by reports submitted to Benton County and Oregon Department of Environmental Quality, and that complete inflation of the terms during last night's hearing does not instill a solid plan moving into this. The lack of clarity obfuscates the parameters of the odor model and how they plan to comply with conditions of approval. Finally, I want to observe that the applicant has chosen not to deploy air monitoring as a technique for corroborating the findings of their odor study. The applicant has even submitted 2 other studies done at landfills experiencing other odor problems, which they used actual air monitoring equipment to measure the level of pollutants in the air. And they have declined to do so for this landfill. SCS Engineers, one of the consultants hired by the applicant, even strongly suggests on their website using air monitors and drones as an assured method to prevent odor nuisances. Ironically, one of the conditions of approval requires that the applicant deploy a hydrogen sulfide monitor as part of their operations. Additionally, as discussed last night, Senate Bill 726 might require the use of drones depending on how DEQ structures the rules, but again, this would not start until 2027. This seems to be placing the cart before the horse. Instead of the applicant clearly demonstrating they are keeping hydrogen sulfide levels at adequate concentrations to prevent odor nuisances, they are allowed to expand their operations and then do so. Additionally, the applicant and county staff made it very clear last night that these conditions of approval are only related to the quote new landfill. How will we know if the hydrogen sulfide levels measured on these air monitors come from the old landfill versus the new landfill? Beyond Toxics has decades of experience with this exact conundrum, and I can tell you it is next to impossible to meet an evidentiary standard that a multi-billion-dollar corporation wouldn't be able to have dismissed. This means that the applicant will have the ability to blame high levels of hydrogen sulfide on the old landfill and claim they are still operating in conditions of approval. This conundrum makes many of these conditions unenforceable, and this problem extends beyond odor. Additionally, the other conditions related to odor are based on someone smelling the air and then smelling a concentration of hydrogen sulfide and making a subjective determination that this constitutes a nuisance. This means that we will be stuck in a he smells, she smells conundrum constantly. Even if the county chose to invest in COA enforcement, meeting the evidentiary standard would be impossible. As one last note, ending my testimony, some additional comments in the written record. The Planning Commission has 2 different sets of data in front of them that lead to different conclusions on the issues of odor. It is your decision and your discretion by Benton County Code which set of data you choose to value and choose to use in your decision. So with that, I can answer some questions.
Commissioner Struthers.
Just one quick clarifying question. So we got this document from you. That's one. I'm assuming there's a bunch of documents that just haven't made it to our way. You mentioned that you submitted some annual reports for the 930,000. Is that in this one or is that additional document?
It will be in another one that I just submitted tonight.
Okay.
That one was drafted up before I heard last.
Perfect. Thank you.
Thank you, Mr. Levitt. Appreciate it. Oh, yes, Commissioner Lee.
So I'm sorry, I would like to have clarification on the model that used 1.5 million tons per year. I'm sorry, I couldn't hear which model. I thought I read that somewhere, but I would be happy if you would point it out.
Yeah, so none of the models put forth by the applicant use 1.5 million tons. They have stated in their application that it will be their waste intake. And when applying for their air contamination discharge permit, Title V permit by DEQ, they stated an intake rate of 1.5 million tons. And that is in the record that I just submitted that you don't have yet.
Thank you.
Commissioner Cash.
Thank you, Chair Fowler. Thank you, Mr. Levitt. Could you say slowly the name of your organization, please?
Beyond Toxics.
Beyond Toxics. And is that organization here in Benton County?
It's based in Eugene.
Thank you. Thank you.
Thank you, Mr. Levitt. Okay, now I'm a little confused, but I think I've got it straight. Next on the next up is Ms. Mersha, but ceding time to Ms. Bradley, and then following that presentation is Mr. LeBlanc, who's ceded time to McKenna Bradley, I believe. And after the Bradleys provide their oral testimony, we will take a break.
I also have James Riddell's time as well, number
Thank you.
23.
Thank you. Please proceed.
My name is Erin Bradley, 38578 Highway 99W, Corvallis 97330. I'd like to thank you for the opportunity to get up and speak again. Our farm is one of the closest neighbors to Republic Services' proposed expansion on 2 borders. There's a few things I think you should hear about that have happened in the last few weeks. Can I move that close? There we go. Is that better?
That is.
Okay. Thank you. Since we last gathered here, there's a few things I think you should be aware of. McCollum Rock Drilling called on May 28th at 10:49 a.m. from an unknown and blocked number. They left a message saying the blasting would occur on May 29th between 12 and 4 p.m. If we had any questions or concerns, please call Republic Services. They did not leave a phone number to call, and I could not return the calls to the number. I was unable to find a phone number online where someone would answer. I finally left a voicemail at Valley Landfills and hoped for the best. This was around noon at this point. I did not receive a phone call back that day. The next morning at 8 a.m., I drove around the corner and went into Republic's office. I asked that somebody please return my call. I did have a call back, and it was pretty prompt, and it was from Republic's environmental person. He did answer my questions. I wanted to know the location of the blast and why they were blasting again, because I was under the impression that we were done with the blasting. I explained what we did and the services we provide for Benton County and mentioned the stress on the animals and clients. He said he would call back the following day and follow up with me. We did not receive a phone call. The blast was extremely loud. On June 10th at 9:20 a.m., I received a phone call from Emily at McCollum Rock Drilling. The voicemail said they would be blasting that day between 12 and 5. She mentioned that she had tried to leave a voicemail the day before and reach out. I called her back and let her know I did not receive a call and there was no number or record of it on my phone or no caller ID. She nicely apologized and said that it might have been a problem on their end. I asked her nicely to see if they could please change the blasting days to Fridays as they were more flexible for us. She left me on hold and came back quickly and said that they could, but it was up to Republic Services to change the day. I then hung up and called Republic Services environmental person, and he did promptly call me back. I left a voicemail. He promptly called me back, and I let him know we definitely heard and felt the blast on May 29th and June 1st. I let him know that we did not receive 24 hours notice of the blast and the impact on our clients and animals. I mentioned the drilling company could change the days to Fridays. He said he would ask his people again. The blasts were never changed to Fridays, and you can see the relationship we've had in the last few weeks. The blast caused additional stress on the animals and scared one of our volunteers, even though she knew it was probably going to happen between certain animals or certain hours. I did manage to record the blast on June 10th on the northwest corner of my property. I've printed it out for you to see. You should have a copy. The first slide is a semi truck going south on 99W, passing in front of our property. The second is the blast. There's quite a difference in decibels. For a blast that we may not have heard or felt, I disagree. Republic Services has increasingly affected the use of my land, placed stress again on my livestock, volunteers, clients, and affected a service to the community. Last testimony, I mentioned the groups we serve. I failed to mention we are a provider for the state of Oregon DHS Child Welfare. We are often contracted by them upon need and currently have clients of theirs writing. We are a service. We are a farm, we are a service, and we are an adjacent property. The proposed facility cannot be operated without noise and odor that will affect our business and other agricultural activities on the property. There are no conditions of approval or other mitigation measures that will resolve these issues. The proposed landfill is a massive industrial complex that cannot be mitigated and must not be approved. If approved, we may lose the ability to operate entirely. The land would become uninhabitable, most likely, for our program and for our animals. After seeing the last staff report and seeing the recommendation for approval and conditions, I called a real estate broker. She said that due to everything we are experiencing and the conditions we are living with and the location, it would be a hard sell. We looked at properties comparable to what we had, and none were affordable. We request you reject LU 24027 and ensure our continued service to the community. The proposed expansion would seriously interfere with the uses on our adjacent property and violate section 53.215 parentheses 1. Thank you.
Commissioner Cash.
Thank you, Chair. How close are you again, please? Where's your property located?
We are just south of Coffin Butte Landfill. We border their, I guess it's, they have the forest land and they have the 10-acre parcel that wraps around. So when we look north, we see their property. When we look to the west, we see their property. I could throw a stick over. That's how close we are currently.
But you're looking onto their forest barrier, the acreage that's the barrier.
Correct.
Thank you.
Mhm.
Thank you, Chair.
Commissioner Bisco.
Thank you, Chair Fowler. The visuals of the sound, is that part of a testimony that's been submitted? Or is that, so I saw just a flash of the first one and then the blast, whatever that diagram or that visual is that something that we will have access to? Or can it be submitted so that we do have access for this record?
Yes, Commissioner Bisco, it's been marked in the record by our reporter, and so it will be posted to the document management system.
Very good. Thank you.
Here in the room.
Thank you, Chair Fowler, for that clarification.
Thank you, Ms. Bradley.
Thank you.
Mr. LeBlanc has ceded his time to Ms. Bradley.
I also have November 24th.
Thank you.
Please speak closely to the mic.
So,
Thank you.
my name is McKenna Bradley, and I live at 3578 Highway 99W, Corvallis, Snack 7330. And I post a land use application LU 24-026. My home is south of Coffin Butte Landfill Road, and it shares two borders with the proposed expansion. I am 17 years old, and a senior at Crescent Valley High School. I am also entering my freshman year at LBCC to complete college credits during high school. I'm also highly involved in 4-H and am in 3 different 4-H clubs. I am, as well as in the clubs, I'm also the president of 2 different clubs. I competitively raise high dollar show cattle at regional and state level. I have a cow potato that has won multiple Supreme Championships when she was a heifer. Her calf Paisley I bred and raised and now is 11 months old and beginning her show and jackpot career. On top of all that, I breed and show Nigerian dwarfs and I show horses. I want to share with you my lived experience of being next to the landfill and on the bordering property. I have collected bags of trash from my property to give to you guys. On the bag, there is causes of what this could do to my animals because it was found on my land. These are found mostly right behind my property. They have flown above the trees of our property onto the ground and almost into my animal pens. On the side of the road, they have flown into my pastures. For years, this trash has been accumulating and is now embedded in my property. And it is a hazard when the roots are pulled up by my grazing livestock, the ones I have worked so hard to breed and raise. Did you know it doesn't take a whole bag of trash to kill an animal? Did you know all these animals can have reproductive issues because of this trash? If you didn't, I provided 2 different studies that are both peer-reviewed and fact-checked. As you know, when things aren't peer-reviewed, they often have mistakes found in them and are not almost factually correct. My cattle have been purchased by the profits of animals I have sold off of my property. All of them sold during 4-H auction. I put over 3,000 hours into each animal I raise. I can't use my pastures anymore to put my livestock out to roam right now because I can't risk my animals dying. Because of this, I have to hand walk my cattle daily instead of leaving them out to roam happily outside. This increases the cost of my hay bale and has my fields to be manually cut, which increases the fire risk in the summer. Another reason I can't put my livestock out is if I lose my livestock or they remain undue, bred to fertility problems, it affects my funds set away for college. I plan to join the LBCC nationally ranked livestock judging team after I graduate high school. I also plan to go into a 4-year university and get my degree, ultimately receive my master's and PhD in animal nutrition. If I miss one piece of debris similar to what is in these bags, I may lose a lot of livestock and profits. This would be a big loss for my schooling fund and also the loss of one of my friends. The landfill's recent blasting has left my cattle stressed and on edge afterward. Like dogs, like animals' first time experiencing fireworks, this is similar to what my animals experience. All in all, LU 24.027 land use application needs to be denied entirely, not just under conditions. Not just for the future safety of my animals, but for the next generation of kids that will inherit land near the landfill. Thank you.
Thank you, Ms. Bradley. Any questions for Ms. Bradley?
I'm okay, thank you.
And as indicated, we will take a break and we will reconvene at 7:40, promptly at 7:40. Thank you. calculation, we have we've gone through, I believe, 20 members so far, and that puts us a little behind time. And so we'll need to be very mindful of time to keep on track. And we will resume with speaker number 7, Ms. Hall, with speaker number 8, Mr. Sarlos on deck.
Good evening, Chair Fowler and Commissioners. I'm Camille Hall. I live at 7175 Northwest Mountain View Drive, Corvallis, and I oppose LU 24027, expansion of Coffin Butte Landfill. Thank you for the long hours and time you've put into this review. The CUP is really the only chance that Benton County has to protect the rights of residents in the properties that would be profoundly impacted by this expansion. Once the CUP is approved, not only will the tonnage cap be lifted, but Valley Landfill will be free to operate Coffin Butte Landfill with insufficient state and federal regulatory support and lack of county resources to develop the rules and expertise to effectively monitor this privately owned landfill. Republic Services is a $75 billion corporation with 200 active landfill sites nationwide. It is not focused on the needs of this community. That's our job as a county. The CUP is the only place the county has the power and authority to protect adjacent property owners and their ability to live and work on their property. The primary thing I will address is groundwater protection for properties adjacent to the expansion site. The applicant's supplemental response concerns our groundwater concerns state the focused hydrogeologic investigation will occur after the CUP as part of the site development permit. This information is necessary now to prove that there is no serious adverse impact on those properties. We need to know in site-specific terms how the blasting and excavation might affect groundwater and wells on those properties. The applicant's plan relies on test wells and mitigation in response to perceived damage. This after-the-fact approach meets the need of the landfill operator, but it completely fails to protect the adjacent property owners from serious and irreversible damage if groundwater is diverted, if well levels drop or are contaminated. The discussion and map on page 56 of the supplemental staff report deals with groundwater flow internal to the expansion site. Republic Services asserts that there will be no crossover of groundwater from the landfill onto adjacent properties as a result of blasting, and they fail to discuss the direction of groundwater flow from the top of Tampico Ridge and the blasting zone onto those adjacent properties. The overarching problem is the highly technical nature of this application. This is through the review, staff and agency comments specifically defer to the applicant on topics where in the course of the regular duties, staff does not have the authority or expertise to comment. We cannot let these issues slide. In these cases, we ask that the appropriate agencies and unbiased topic experts be called upon to evaluate the applicant's work. In the case of groundwater protection, we specifically request Oregon Water Resources Department be notified of this expansion application and the water quality issues raised by the community. From 2010 to 2016, Coffin Butte took in 500 to 600,000 tons of trash per year. Beginning in 2017, annual tonnage doubled. We know firsthand the impacts of these tonnage and activity increases. The decision to approve the CUP enables Republic Services to continue this trend to fill space quickly and come back for another expansion. I urge you to deny this application. Through the CUP, the applicant has finally offered some remedies to the worst longstanding operational problems that have plagued this site. They could have done that sooner, and they didn't. It was only because they had to that they did that, dealt with litter, odor, and noise. There is more work to do, and denial of the CUP is the only leverage you have to protect groundwater and adjacent property owners' rights. Thank you for your time, and I encourage you to not deny this.
Thank you, Ms. Hall. Ms. Sarlos with Ms. Foster on deck.
I have seated time from Laura Hansen. Number 27, my name is Jenny Sarlos, and I live at 390 Northwest Maxine Avenue, Corvallis, Oregon. I urge the Planning Commission to deny the landfill expansion. The proposed expansion would seriously interfere with the character of the surrounding area in violation of Benton County Code 53.215. It would jeopardize the air and water quality. Traffic will increase, odor and noise will increase. There will be potential long-term climate and environmental consequences. This alone is a solid basis for denying the expansion. We can't continue to bring garbage from all over Oregon and even other states and not change the character of the surrounding areas. We absolutely need to deal with our garbage, but other places do also. When it comes to taking in garbage, Benton County has more than done its fair share under the current agreement. I would like to add that this expansion would cause a serious burden on the many properties that surround the landfill for miles. I am aware that the potential harm will not be limited to these areas, but I do feel that these residents of our county face an even more terrible burden if this expansion is passed. It is bad enough to smell an odor, but then one wonders what kind of toxins they might be breathing in, wonders if the leachate will reach the well water, wonders what will happen to the property value, wonders what way the wind may blow. This is no way to live. Please put a cap on this problem. No amount of monitoring will make this expansion bearable. Promises can be made to keep the leachate from getting into the groundwater. Can you hear me? But there is no way to guarantee that. Promises can be made to contain odors and contain garbage, but that is not always possible. Garbage stinks. Accidents happen, even under the best of circumstances. Fires happen. And can we really ask a volunteer fire department to be on the ready for a fire at the expanding landfill? The Benton County 2040 Thriving Communities Core Values Initiative has at its very center equity and health. Please uphold these values. We cannot have equity if the concerns of the surrounding area are invalidated. And by that, I mean saying things like, that odor is not a nuisance, it is a mere annoyance. Who gets to decide these things? The Benton County Core Values goes on to state that we recognize and will address the well-being of our people by including health considerations in all policies, practices, activities, and operations. The burden imposed by the expansion of the landfill to residents of the surrounding area are a threat to their mental and physical health. Please uphold our core values and preserve the character of this beautiful place and deny the landfill expansion. Thank you. Questions?
Thank you, Ms. Sarlos. Appreciate it.
Thank you.
Next is Ms. Foster, Mr. or Ms. Foster, number 10. Oh, thank you. Then Ms. Palmer, number 12. And then Mr. Higgins will be next. Ms. Palmer.
Hi there. My assigned number is 12, and the people ceding time to me are Andrew Ould, number 28, and Martha Trininger, number 39. Chair Fowler, Vice Chair Hayman, members of the Planning Commission. My name is Debbie Palmer, and I live at 37340 Moss Rock Drive in Soap Creek Valley, about 4.5 miles south of the landfill. I second everyone else's gratitude for all the careful time and attention you are putting into this. And if I understand correctly, you plan on extending tonight's meeting time if needed in order to hear all the public comment instead of cutting us off at 8:45 p.m. like you could have. We really appreciate that. We appreciate you granting us the same consideration as you granted Republic Services and county staff. So thank you very much. My testimony tonight will be in response to information presented at last night's meeting from both staff and the applicant, and in no particular order. For starters, this may seem a bit minor, but have you noticed how Republic's visual presentations never actually show pictures of the dump itself? They'll show you nice pictures of the surrounding area, beautiful grasslands, rolling hills, etc. Dare I say, pictures of the character of the area. I hope this is not lost upon you. They will never show you pictures of the dump because it is ugly. Who would want to look at that? Exactly. Another thing, this is regarding fire. Republic's fire consultant has never once mentioned evaluating the impact of wildfire in nearby forests, i.e. he has studiously avoided investigating how likely it is that a major landfill fire could be started due to wind-blown embers from a wildfire landing on this methane super emitter. Does that not sound like something that should have at least been considered? It sounds apocalyptic to me, frankly. This is just another example of Republic's failing the burden of proof test. Moving on, Chair Fowler, you were on the Planning Commission in 2021 when Republic's last expansion application was soundly and unanimously denied. Do you happen to notice how this current application is uncannily similar to the first phase of that one? Everything points to Republic's intention to continue to expand this monstrosity, that this is just the first step in what will be a series of applications to expand. Why would they be spending all this money and taking 3 to 4 years to construct something that will only add 6 more years of landfill life? They're not going to stop there. Soon as this phase is largely underway and as Cell 6, the quarry, rapidly fills, thanks to the cap being lifted, they're going to apply again. In an email exchange between County Counsel Vance Croney and Republic's Julie Jackson during the 2020 landfill franchise agreement negotiations, information we got via public records request, Mr. Croney says, quote, "I want to be sure I'm correct when I'm discussing with the BOC ramifications of lifting a tonnage cap." And Ms. Jackson replies, quote, "We have many acres that could hold waste, and that will likely be a future discussion with the county." So they're definitely intending to continue to expand. Actually, I'll amend what I said about this being the first step in a series of applications to expand. We are actually extremely concerned that if you grant this expansion and Republic now owns a landfill on both sides of Coffin Butte Road, that they could, under Oregon statute ORS 368.351, vacating without a hearing, get Coffin Butte Road vacated by the county, i.e. permanently closed, and build their landfill across it without a public hearing. Possibly even without having to notify the public. Or in other words, without having to be held accountable via a formal public application process like the one we're going through right now. Because that is our biggest fear and Republic's dream scenario. Moving on once more, regarding compliance with past conditions of approval. Outside counsel Meg Ryan states it's the county's legal obligation to monitor the conditions, and there is a legal process for enforcing conditions should the county have the budget to do so. And planning official Petra Schutz says, until adjudicated, we don't have any evidence that those conditions were not followed.
So apparently, all our filed complaints and photographs and such are not sufficient evidence. What we all can see with the naked eye and smell with our noses is not sufficient evidence. It sounds like what they are both saying is that someone would actually have to sue in a court of law in order to prove past conditions were not met. That is what adjudicated means, right? We know the county would not do that, even if they had the budget. So that means some member of the public or organization would have to sue. Does that sound like a level playing field to you? Next, Republic's fire consultants attempt to claim that because this dump has been around 70 to 80 years and hasn't impacted nearby properties thus far, and therefore would somehow on a go-forward basis not diminish them, is feeble and specious. 15 to 20 years ago, let alone 70 to 80, the landfill was a fraction of the size it is now. Its collective impacts are a huge question mark on nearby property values going forward. Lastly, I wish to remind you that your decision is ultimately discretionary. That's in the code. So under your quasi-judicial authority, you have the leeway to judge this application as you see fit. If you feel a concern is valid, then it is valid. I hear a number of you expressing concerns about what you can and cannot consider when judging the application, such as past performance of Republic at their landfill across the road from the proposed new dump. Past behavior is absolutely a valid consideration when judging future behavior. Please use your power of discretion and deny this application unconditionally. I thank you for your time and relinquish any leftover time on my clock to the next speaker, or if that's not allowed, let it expire.
Thank you, Ms. Palmer. Next on the list is Mr. Higgins, followed on deck by Mr. Kanaga. And Mr. Higgins, if you can remind us whose time is within your budget of time.
I've got Marge Pop, number 13, Josh Dodson, 25.
Thank you.
Chair Fowler and commissioners, appreciate the opportunity to speak tonight. My name is Kevin Higgins. I'm a retired fire captain from Adair Fire with active over 20 years in the service there, retiring in 2022. I'm also the former emergency manager for Benton County. Still work at the county, but I moved on to become a special services manager for the sheriff's office. I was asked to speak on my accounts of fighting fires at the landfill. When I started in Adair Fire, we were still having routine fires at the dump, some of them very big, multiple alarms, and many agencies needed to fight these fires. One particular fire, it's been talked about several times, was big enough to make the Associated Press. That was the fire of 1999. Some of those fires took all night. That one was one of them. Took all night to get out since the fire would be deep into the trash and would often require us to bring in dozers, excavators to move the trash so we could get to the seat of the fire. Fires use a huge amount of water to fight. And the landfill folks, I understand, they hate it when we use tens of thousands of gallons of water to put out their fire. It throws off their leachate. And I know the fuel load is enormous at the landfill. That's why the fires require so many resources to fight. Fighting a fire there is one of the worst locations to fight a fire due to the unknown substances burning. It is so toxic that you basically have to fight the fire on air the whole time. You're wearing an SCBA pack on air for hours, but if you don't go on air, you usually cough and feel sick for days. Who knows what that has done to each of us that have fought fires and not being on air. I often wonder what kind of toxins were released into the air that not only we were breathing, but may have affected the environment. Excuse me. My son was also a firefighter for over 10 years at Adair Fire. Although he did not experience the 1999 fire, we both had similar physical effects after fighting fires at the landfill. We both experienced our eyes got sticky and goopy, and both had burning in our lungs if we weren't on air the whole time. Our lungs would burn for days, and we'd feel lethargic and sick. The smoke was thick, black, and heavy, and you just never knew what was going to be burning next. I imagine a scenario where we had a large wildfire that included the dump. We would have a toxic mess on our hands. A typical wildland crew wouldn't have the equipment or the experience to fight a fire at the dump. And a structure crew would prioritize working on exposures, protecting homes and buildings. That doesn't leave many resources to actually fight the fire that's at the dump with all of its toxins. Over the years, they did start doing something different because fires started to decrease in frequency. The last few I went to started in equipment operating at the dump, and then sometimes would spread to the noxic trash. So we had an equipment fire and a trash fire to deal with at the same time. This often required mutual aid from Corvallis, Albany, and possibly Polk County Fire to assist. In the early days of tarping, I can personally remember fires that were under the tarp, feeling the methane explosions under my feet. Back then, I had to personally make large cuts in the tarp themselves to release the methane buildup so it didn't explode on our crew. I have heard representatives from the landfill say this never happened. I can tell you it did. I was there. I cut the tarps and burped that methane out. So if you weren't there, you can't say it didn't happen. And they weren't there. It was an eerie sensation to feel the weight of the dump exploding under your feet. My son Levi had also experienced the explosion under the tarp and said it was terrifying watching and feeling the fire hitting so many hazardous materials and seeing the color of fire change, which is inherent to toxics. Different toxics have burned differently. I've heard testimony from supposed experts that say, excuse me, that say since the 1999 fire, there's only been a few fires. And I realized that the expert last night kind of backpedaled and changed that to that's the only ones he was referring to. But in his earlier testimony, he said there was only a few. I'm also reporting that is not true. I don't remember seeing those experts up there. I have no idea where they got their information, but we had no less than 2 fires per year for many years, and that's being very conservative. And every fire is dangerous because you have no idea what's burning and what's going to burn next. Now, granted, there were fires that were in the equipment that didn't spread to the trash in the dump itself. That was mostly because we being the local volunteer fire department, were able to get there in a timely response and quickly contain the fire to the equipment. The Higgins family moved to Soap Creek in the early 70s. That's where I was raised and have memories of going to the dump as a kid looking for treasures. It was almost flat in the 70s. You could walk up there, rummage through, pick out speakers out of TVs, make a cool stereo system. I did it. That was fun. I was a young inventor, and the dump was a lot different then. My wife and I decided to move back to the Soap Creek Valley in the late 90s to raise our family. Now our son and his wife are considering this as well with their kids. That would be 4 generations. And so for our family, the stakes are high. We want to protect and preserve the beauty and health of the Soap Creek Valley and Benton County. The whole landfill issue is frustrating, and expansion seems to be about greed. I hope the county commissioners that are smart enough to fulfill the commitment made many previous commissioners ago to wind down the landfill, not expand it. Yet again, what a disaster it would be for them to overrule basically 100% opposition to the landfill with only a couple of supportive voices. And those are all money-driven. Republic Service, the county itself, and trash hauling companies from outside counties. Nobody else seems to be in support. In closing, two things. To be clear, I am 100% opposition of any expansion to the dump. And second, I looked online for Benton County's commitment to the environment, and this is what I found. It should help in your decision-making process. Benton County, Oregon demonstrates a strong commitment to environmental sustainability through various initiatives and plans. The county aims to reduce greenhouse gas emissions, protect natural resources, and promote sustainable practice in the area like waste management and land use. Thank you for your time. And I also realize I didn't give you my address. Still want it?
I think you may have provided it when you checked in. Is that
Okay.
true? Commissioner Wilson.
Thank you for your testimony this evening. The question I have is, as it relates to firefighting, when you encountered or dealt with and suppressed fires at the landfill, did you find any evidence that there might have been subterranean fires? You talked about the potential, the explosions of the methane were just subsurface, but did you see any potential for subterranean or deeper smoldering burning?
Yeah, so there would be times we would be digging 6, 8, 10 feet down. And it might, I've been retired for 3 years now, so I haven't fought a fire in that time. I don't know if it's changed since then, but I kind of doubt it based on the fuel load. So if you want to consider 8 or 10 feet subterranean, that's true. Now, there's way back in the day, there was metals buried in I think in probably the first section that are water reactive. So if you core drilled that and hit water, they can actually have very bad consequences of hitting water reactive materials that are still buried in there. So we didn't ever get that deep, of course, but yeah.
Thank you, Mr. Higgins. Appreciate it. And I see that Mr. Kanaga has ceded his time to Mr. Yeager. So Mr. Yeager is next. And if you could help us, Mr. Yeager, to inventory the time that you'll be using from others.
Yes, I will do that. Let me see here. So the list I have I have Kevin Canegas, Becky Legrand, Jennifer Johnson, Susan, I think this is Dormfeld, Roxana Cafferly, and Ann Weinstein.
Let's see, I also have Joel Weinstein. Is that accurate?
No, I'm sorry. Joel has been moved to Kate Harris, and we've worked that out with the front desk. So, Kate Harris will have Virginia Scott and Joel's time.
Thank you. I'll try to keep track of all that. Thank you.
So let's see, what do I have? 21. Okay. Good evening, everybody. Chair Fowler, members of the commission. My name is Mark Yeager, and I live at 37269 Helm Drive in Corvallis. I want to thank the members of the Planning Commission for their work on this application. I know that your work has been difficult, and we appreciate your service. I also want to thank and express my gratitude to the community that has come out to engage in this process. A small group that was once characterized by the county as a bunch of NIMBYs has become a region-wide movement to demand a new way forward for waste management in Oregon. The Figure 8 graphic in the staff report and the more than 1,300 petition signatures show a broad base of support to stop this landfill expansion. I want to talk a little bit about prior conditions of approval. I served on the BCTT subcommittee that reviewed the entire record of every prior land use decision regarding the landfill site. 8 months worth of work. At the conclusion of our review of all prior land use proceedings, the public members of our subcommittee developed key findings that can be found beginning on page 98 of the BCTT report, which has been entered into the record. The BCTT report that the applicant and staff rely on heavily for their definitions to craft their proposal also discusses landfill compliance and prior conditions of approval. Key finding F2 states, and I quote, Benton County has not and does not actively monitor compliance with many conditions of approval, nor does it proactively act to enforce compliance. This finding was adopted unanimously by the voting members of the BCTT. A thorough review of the Coffin Butte Landfill's historical land use conditions, as documented in the BCT past land use conditions committee's report and appendices, reveals a pattern of non-compliance by landfill operators and a systemic failure by Benton County staff to enforce conditions of approval and ensure accountability. The county readily admits that it does not have a system in place to monitor compliance with conditions of approval and that they have no staff or resources to enforce compliance. More key findings from the BCTT report. F3, Benton County relies on complaints to initiate action to enforce conditions of approval. Benton County did not, this is F10. Benton County did not and does not have a readily accessible, transparent, complaint tracking system. Sorry for my voice, I've got a little bit of a cold. Known to the public in place to receive and record land use complaints for documentation, investigation, and resolution. Both of those findings were also adopted unanimously by the BCTT. Has the county done anything toward implementing the recommendations that came out of the BCT in this area? The answer to that is no. Two specific and measurable examples of non-compliance with prior conditions of approval include the screening requirement in the order for PC 8307, item number 10, states, screen the landfill operation with fencing or berms so it cannot be seen from the county road or adjacent properties. That is clearly not the case today. And as noted in a recent newsletter from Senator Gelser-Bluen, quote, driving through the countryside, the mountain of waste is impossible to miss because it towers above the fields and trees around it. A second example of explicit noncompliance comes from PC 0207, wherein condition of approval number 10 states that the landfill activity is to be required to be limited to 600 feet contour elevation. The applicant's submittals and drawings for this proposal on page 64 of the supplemental staff report clearly show the elevation of the existing landfill is 625 feet, a clear violation of a prior condition of approval. The landfill operator unilaterally exceeded the height limitation on the existing dump, and the county has done nothing about it. To my knowledge and to the knowledge of the committee that worked on the BCTT to review these issues, the county has never taken any enforcement action against the landfill operators in response to non-compliance with conditions of approval. Based on recent staff testimony, the new code enforcement person will have no role in monitoring or enforcing landfill conditions of approval. So conditions of approval are required when proposed development is incompatible with surrounding land uses and may have an adverse effect on nearby properties. Those conditions of approval have been determined to be necessary to mitigate adverse impacts. But if the conditions are not implemented and not enforced, they are worthless. The landfill operator's consistent disregard for land use conditions paired with Benton County's non-existent oversight has undermined the integrity of the land use process The county's unwillingness to challenge noncompliance through penalties or corrective actions has allowed Republic Services to operate without meaningful accountability, contrary to the public interest and intent of conditional use permits. I'm going to talk a little bit about the bias in these proceedings. Since 2020, with the adoption of the renewed franchise agreement between the county and Valley Landfills, the history in this case is a sordid one. The county staff and the developer have been exclusive partners in attempting to force this expansion upon the residents of the county. Their efforts to disenfranchise residents have been numerous. Yet the understanding of the short and long-term impacts of becoming Oregon's trash depot has filtered throughout the community, and the outrage has continued to grow. The NIMBY moniker applies now to many residents of Benton County. We don't want to become Western Oregon's trash can. The county will be paid a minimum of $1 million per year in exchange for approval of this conditional use permit. I refer you to Section 4 generally of the franchise agreement, which is also in the record, and Sections 4C1 and 4C2 specifically in the 2020 franchise agreement. We have been told by county staff and others, it's not about the money, but what else could it be? Do you know of any previous land use proceeding where the applicant guaranteed to pay the county money in exchange for approval of a development proposal? I don't know of any. Following the county's failure to get its planning commission to approve the 2021 expansion application, which was denied unanimously on a 6-0 vote, 4 of the 6 commissioners left or were not invited back. Shortly thereafter, the county adopted a massive appeal fee increase that requires a $5,000 deposit and a signed blank check to cover all costs incurred by the county to handle an appeal. And it only applies to landfill conditional use permit applications, no others. Talk about disenfranchisement of the residents. I want to talk a little bit about litter. You have received testimony from numerous commenters about widespread presence and impacts of windblown trash from the dump on nearby properties. The proposed mitigation measures will have little or no effect on the litter situation, and moving the dump closer to the impacted properties will only make the problem worse. I'm entering testimony of Angela Kruger and Ryan Wilson into the record this evening, and that's been turned in up front. They have many, many pictures of windblown trash on their property where they graze their cattle. They also have a video of a cow munching on a piece of plastic just from the other day. But there doesn't seem to be any way to submit videos in this process. Like the Bradleys, the litter from the proposed dump operation will seriously interfere with use of their adjacent property and threaten their livelihood. Moving on to stormwater and water quality impacts, the proposed drainage plan submitted by the applicant through their consultant CEC directs runoff from the LS property through an outfall from the southernmost stormwater basin onto rural residential property. This is not allowed. The wheels on trucks exiting the dump, particularly during the winter, are often covered with contaminated mud from the working face. This mud is tracked onto the surface of nearby paved roads, Coffin Butte Road, Highway 99, Camp Adair Road, and either washes off into roadside ditches, or the dump water truck is used to spray the mud off the road into the ditches. This stormwater is contaminated. The practice must be prohibited. A truck tire washing station should be installed just prior to the exit onto paved roads. Moving on to noise. The applicant proposed mitigation measures for noise reduction and neglect the many instances of sharp noises that come from activities near the working face. These include the clanging tracks from the bulldozers working in and around the working face, the banging of garbage truck doors when the drivers go forward and quickly stop to encourage trash to fall out of the bed, and the horn blowing that is used to communicate between trucks that are on the working face. Managing noise from the on-site vehicles, which is what they're proposing, touches a very small fraction of the vehicles entering the site and will do very little to reduce overall sound levels. Noise levels from the proposed expansion will be closer to many properties and will seriously interfere with uses on adjacent properties. The proposed hours of operation will allow the dump to start internal activities at 4 a.m. and extend until 6 p.m. 6 days a week, 14 hours a day. And now they're proposing to be open on Sundays as well. This is unacceptable and represents serious interference with uses on adjacent property. Moving to odor. Either the folks that are doing the odor studies don't actually get what is happening, or maybe they think the public is naive. The odors from the dump do not emanate in a uniform fashion or get transported off-site in some simplified pattern. I live 5 miles south of the dump, and I regularly smell it so strongly that I must limit my outdoor activities, such as running or biking. Further, on numerous occasions, I've smelled the landfill odor in North Corvallis on 9th Street, more than 9 miles away. Also, as a bicycle and motorcycle rider, I know how pockets of air settle in different areas and contain different temperatures and odors. This regularly happens with landfill odors. Further, going out with sniffer devices and logging instances of odor detection and measurement, it doesn't do anything to control the odors. The proposal of a self-established limit of 930 or 934,000 tons of organic waste annually is a non-starter. First, since organic waste generally makes up 40 to 50% of municipal solid waste, 930 annual tons of organic waste will mean that they'll be bringing in 1.8 to 2 million tons of waste a year. A dramatic increase over their current tonnage of 1.1 million tons. And having spent many, many hours observing landfill activities at the working face, I have never seen a single instance of a garbage truck audit like they were talking about yesterday. Like someone's going through the garbage. This is all self-reported. People come in, they say, "Oh, that's what I have in my truck." And the pictures of in the record, there's pictures in the record of illegal material going into the dumpsters around Albany and Corvallis, tell you that Republic does nothing to manage trash going into the dump. TVs, monitors, all kinds of different things. To assert that somehow they're going to limit the amount of organic waste coming into the dump, it's not believable. Also, the annual limit is meaningless in terms of consistent loading. They're talking about odors. They could bring in 750,000 tons of organic waste in 4 or 5 months in the summer, causing massive increases in odor emissions. The odor impacts from the existing facility seriously interfere with activities and property uses over a wide swath of Benton and Polk counties. Adding more waste by expanding the dump and increasing the annual tonnage will make matters worse. Talking about review criteria, after the lengthy and contentious expansion application in 2021, the county moved quickly to erect a huge barrier to landfill-related appeals of any planning commission decision by members of the public. And with all the hand-wringing about the qualitative nature of conditional use permit review criteria, Benton County still uses a one-size-fits-all for any conditional use permit. They did nothing to modify the criteria as it applies to landfills, unlike what they did for the appeal fees. So they're using the same criteria for a landfill that they would use for a dog grooming shop in a residential area. It doesn't make any sense. And they have done that to allow themselves leeway to approve this application. They're not interested in protecting the people or the environment. I find it disgraceful. Just a little bit of history. 1974, there was significant resistance to the designation of Coffin Butte Landfill as a site to serve a small portion of a few adjacent counties. I had a letter in my last piece that I gave to you from a gentleman who wrote during that time frame. In 1983, during the rezoning process, county residents once again sounded the alarm about this dump and were steadfast that no trash should ever be placed south of Coffin Butte Road. Again, in 1994, there were dozens of letters submitted against the proposal to expand the landfill site into the rural residential zone, and that expansion effort was defeated. But this effort will just not die. In 2021, a unanimous Planning Commission decision denied a similar expansion request to the one that's being proposed now. But here we are again in 2025. With all that we know now about landfilling in general and this landfill's operations more specifically, we must have the courage to deny this application and demand a new way forward. The evidence in the record to deny this application is overwhelming. The burden of proof has not been met. This proposal cannot and does not meet the review criteria for a conditional use permit. The evidence in this case clearly demonstrates that the proposed new landfill will seriously interfere with uses on adjacent property and the character of the area. In addition, public facilities such as the E. Wilson Wildlife Area, the Willamette River, McDonald Dunn Forests will bear an undue burden from the impacts of the proposed development. Please deny this application. Thank you for your time.
Thank you, Mr. Yeager. Any questions from Mr. Yeager? Thank you very much, Mr. Yeager. The next on the list is Ms. Scott, who I see has ceded her time to Ms. Harris. Please proceed.
Good evening, Chair Fowler and Commissioners. My name is Kate Harris. I reside at 37268 Moss Rock Drive, 4 miles due south of Coffin Butte Landfill. I have a degree in civil engineering from University of Portland, in which I studied water treatment plants, wastewater treatment plants, and solid waste management, including Coffin Butte Landfill specifically. Thank you for the long hours you've put into this process and your thoughtful consideration of this matter. The future of our county and our neighbors rests upon your shoulders. I do not envy your current task. Thank you to Virginia Scott for her time. Please refer to her written testimony submitted today regarding a rebuttal about fire considerations, including this quote: "Self-monitoring by Republic Services is like the fox guarding the hen house. Thus, approval with conditions is exactly the same as approval without conditions. These conditions will never be met. No monitoring will be done. No repercussions to Republic Services will occur. All bad current behavior will continue unabated on a larger scale, and the community, environment, businesses, forest, land, people, health, air, water, wildlife, etc. will suffer, i.e. dead hens in the hen house. This is the very definition of undue burden." Going off script a little bit, we have a document in the record submitted by Joel Geyer from the Center for Health, Environment, and Justice titled "Landfill Failures, the Buried Truth." You can refer to that document, and the first piece of it being titled "The Basics of Landfills, How They Are Constructed and Why They Fail." You were assured last night by Republic that the liners do not fail. Please refer to this document to learn for yourselves from research data as to how and when they do fail. We know that plastics do break down over time, and there are different components to that, so there's some research document for you there. I am here this evening to discuss the impact of Coffin Butte's current and future operation on waterways, the environment, and drinking water. My points are relevant to this expansion discussion because any expansion will only exacerbate the issues I will raise. To quote the Brockovich Report publication's article, "No surprise, PFAS found near wastewater treatment plants and biosolid applied lands." Quote, "A new analysis from Waterkeeper Alliance warns that 98% of tested waterways across 19 states contain toxic PFAS. and in particular, downstream from wastewater treatment plants and sites where biosolids have been applied. The researchers connected this finding to the disproportionate siting of sources of environmental pollution, including PFAS contamination, such as major manufacturers, airports, military bases, wastewater treatment plants, and landfills that are typically located near watersheds serving these communities. Listen, we know we've had a huge PFAS problem, and now we have more data to prove it. That's a good thing. American communities are exposed daily, often unknowingly, and many face serious, disproportionate health risks. The tools to address the crisis exist, but the political will is lacking. We cannot afford more watered-down regulations and loopholes for industrial source polluters. The science is clear. EPA and lawmakers must act decisively and with urgency in the public's interest. If you get your drinking water from a private well, you may want to test your water to find out exactly what's in it. You can contact a state-certified lab for professional analysis. Some counties may offer free or discounted tests, so check with local authorities first." End quote. Does Republic or the county offer these free tests to residents? Republic testimony yesterday stated that an official from Adair Village said there was not a problem with PFAS contamination. That is most likely true, as it has apparently never been tested, or the very least never been reported to the public. The 2024 water test report is available on the Adair Village website and is submitted along with the Brockovich report in my written testimony tonight for reference. To clarify discussion yesterday about Adair Village, Pat Hare is the city administrator for the city of Adair Village, and I believe he may be the entity referenced by Petra yesterday as the one who was contacted twice but chose to give no input. I do not know if his city council or mayor was privy to that discussion or their ability to provide input. Adair Rural Fire Protection District is a separate and unrelated organization which was never contacted by the county regarding this expansion application, although did voluntarily submit testimony in May. The county did not seek interested party information from the fire district. Back to the discussion of Adair Village's drinking water. Pat Hare and his family live in Scioto, and therefore he doesn't seem to have any specific family safety concerns with the quality of water in Adair Village. He has done a lot of amazing work for the water system in recent years and should be very proud of the work he has done. But that does not guarantee safety. I personally sent an email to him, Adair's mayor, the head of their planning commission, and the superintendent for the school in Adair Village in 2021 regarding concerns for drinking water safety and air quality. I received no replies. I was told third hand that Pat's method for dealing with concerns like this is to simply ignore the emails. Perhaps that is also what he did with requests sent from the county. That's speculation. When I lived on the Adair Village water system from 2014 to 2017, many of us had concerns of extremely high chlorine. Those concerns were dealt with inappropriately by the same staff that is currently working the water system based on my studies in my civil engineering degree. I would not rely on Republic's statement last night that Pat said his water is fine. Where are the tests? If they wanted to prove it was fine, why did Republic not fund PFAS testing for Adair Village drinking water? Isn't that what a good neighbor would do? What about all the neighboring private wells? Where are those test results? Adair water quality won't be a player in this discussion if Corvallis really stops taking leachate at the end of the year. But as we heard yesterday, Republic does not have a plan, so it is worth still discussing. Pat Hare just received confirmation of $4 million from the state for his new wastewater treatment plant in Adair Village. Past discussions have included Republic adding funding for that new plant so they could treat leachate there. Again, speculation, no plans that I know of in the currently. That discharge is reported to be upstream of the Adair water intake in the Willamette River. So Adair water quality really should be part of this discussion moving forward. Until we have binding contracts in place, stating leachate will not end up in local drinking water sources. But where will it end up? Perhaps the discussion should be redirected to what constitutes an undue burden. Any landfill in the Willamette Valley creates an undue burden on the population and waterways in the valley, and thereby on the character of the area. Republic's own corporate website discusses that landfills in arid locations produce very little leachate, often so little that it can be used for dust control on top of the landfill, thereby containing the toxins to the lined cells themselves, not impacting any population, nearby waterway, or character of the area. So perhaps this discussion should be less about what drinking water or well tests have or have not been funded by Republic as a good neighbor, and whether or not this landfill should be here at all. Expanding the amount of leachate produced by Coffin Butte is in and of itself an undue burden to the character of the area, namely the environment and the entire population of Western Oregon. While we're on that topic, please let's ask the county to produce the documentation that shows that the expansion into Cell 6, the quarry, is actually approved by permit. Operations in the quarry may also be an unapproved undue burden to the local population and population of Western Oregon. Republic does have the ability to transport and dispose of this waste in arid locations east of the Cascades via rail, ultimately reducing their truck trips and carbon footprint, counter to the testimony by Linda Brewer earlier this evening. We have seen examples in other counties of waste disposal costs going down with a loss of monopoly and introduction of alternative disposal options, also counter to Ms. Brewer's testimony. This discussion of expansion here in the Willamette Valley needs to stop, and we need to start discussing how to move waste disposal out of the Willamette Valley. Thank you for your time over all of these months. We really do appreciate all of your efforts.
Thank you, Ms. Harris. Appreciate it. I need to pause just for a moment for a procedural issue. We have publicized that public testimony would end in 10 minutes at 8:45. So for the record, I would like to entertain a motion from the Planning Commission to extend the time for public testimony. Commissioner Struthers.
I move to extend the time to complete the list that has been submitted to us for tonight.
I'll second.
We have a duly made and seconded motion to expand the time necessary to accommodate the speakers who have signed in. Any discussion on the motion? Commissioner Struthers.
Just for everyone's knowledge, I informed staff and the chair prior tonight that I do have to leave around 9:15, as my wife has to go to work at 9:30. So I will be joining from Zoom once I leave.
Any further discussion? I will then call for the vote. All those in favor signify by aye.
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 Thank you very much. Motion passes, and we can continue with the public testimony with Speaker 16, who appears to have ceded their time to Mr. Henkels.
Chair Fowler, do you mind having Commissioner Hayman came in at 7:45? Do you mind adding that to the record?
I think you just did.
Okay.
Thank you. Thank you for that reminder.
Thank you very much. And thank you very much for properly recognizing the public's interest in this hearing. My name is Mark Henkels. I'm a citizen of Benton County. I live at 7540 Northeast Pettibone Drive in the Lewisburg area. I'm speaking today in opposition to LU 24-027. I have two concerns which I believe have not been properly clearly addressed in this process, at least until tonight. These concerns tie into how the expansion will affect adjacent properties and the character of the area. The first major category is how waste disposal increases that are projected will shorten the landfill's life and increase the impacts on the community. Republic Services' own diagram tells the story. Once the expansion occurs, they propose to raise the intake from the current cap of 1.1 million tons per year to 1.5 million tons in the first 4 years, a 36% jump, and then up to 1.86 million tons in years 5 and 6. That's a 78% increase over what most capacity projections use. The county's estimate of the 12-year life for this expansion is based on lower volumes. If you increase the flow, the space fills faster. At these levels, the quarry and the expansion combined could hit capacity sooner than if we just kept filling the quarry at the current intake levels. More relevant here for the criteria is that the higher the volume dumped per year, the greater the real impact on adjacent properties and the character of the area. Repeatedly in this process, we have heard how the doubling of the annual dumping in the last decade has affected the surrounded area. And I live 7.5 miles away from the dump, and I am much more, the landfill, I am much more aware of the operations today than I ever was before, and I certainly smell it more often. So this is no longer a small facility up on the hill. It's an industrial scale operation. Expansion means more trucks, more noise, more odor, and a more visible trash mountain dominating Northeast Benton County. The second major area that I am concerned about are how the conditions of approval won't be enough to protect the public. The staff report contains many conditions. I counted 25 that were numbered, many of which contain multiple points. And overall, if you look at all the different points, I heard the number 83 earlier today. I think there could be 87 total specifications. The sheer number of conditions raises a red flag. If this project and if this application is complete and this project truly fit our community and our landscape, why are there so many special rules to try to contain its impacts? Instead of considering whether the impacts on the adjacent lands, public facilities, and the area's character invalidate the proposal, the staff report assumes the proposal's risks, uncertainties, and known consequences have simple fixes. I kind of couldn't help but wonder if I had a contractor come to me and I felt like I better make such an extensive list of additional prohibitions and requirements because I feared how the work would turn out, I would not hire that person. And let's be honest, once the project like this is approved and construction begins, it is very hard to stop it, even if things go wrong. In economics and in management, there's a term called sunk costs. It means that once you've invested time and money into something, you become very reluctant to abandon it. Both the county and Republican services are already deeply invested in this expansion, but will be even more so should this expansion be approved. The staff report recommends a deadline for meeting the preliminary condition of 4 years with a 1-year extension possible, for example. But what planning official would say no to the applicant who says, we've already spent millions, we just need a little more time? So the 4-year deadline, bold-faced in the report, is probably superfluous to begin with. A second, greater concern to me is a staff's report recommendation about what happens if the conditions are not met. The report states failure to comply with the operational approval conditions may result in the revocation of conditional use permit. May result in revocation means very little in practice. The concept of sunk costs indicates that once the permit is granted and once the county is getting used to that flow of money and once Republic Services has increased its investments and its commitment to legally battling any effort to stop it, the operation will never stop. That's human nature, that's organizational logic, and that's actually public administration reality. Now, it's also notable that some of these conditions simply don't solve the bigger problems. A few rows of trees won't hide a landfill that's visible for miles, from Tampico Road, from Independence Highway, from E.E. Wilson. Nor will restore the views of the Coast Range lost to this industrial presence. Finally, as noted earlier, enforcement is a major concern. Many of the conditions here were adopted in reflection of past or ongoing problems. Republic's poor record on methane emissions shows what happens when we rely on the corporation's self-monitoring. The county may require compliance with state and federal standards, but also admits it lacks the capacity to independently monitor or enforce impacts on groundwater, methane, and other air pollutants, leachate, or PFAS. Even for this report, staff noted it lacked the capacity to review the groundwater data. Depending on state and federal agencies for monitoring and enforcement is simply inadequate. The EPA is spiraling downwards, especially in enforcement. The DEQ publicly admits it cannot fulfill its responsibilities. The county does not even pretend to have such capacity. This is just not the right path for our community. Thank you for your time.
Thank you, Mr. Henkels. Appreciate it. Next up is Mr. Eklund. And Mr. Eklund, if you could help me by inventorying the time and speakers.
I can indeed.
Thank
So
you.
number 33, Ilya Silak. Number 30, I'm sorry, am I going too fast?
Nope, go ahead.
Number 34, Matthew Evans. Number 40, Zach Stads. Number 42, John Armstrong. Number 43, Annette Mays. Number 44, John Nelson. And number 45, Rin Ball. And I just want to reassure the commissioners that I'm not planning on using all that time.
Thank you.
Although I will use quite a bit of it. So. Oh, I'm sorry. So thank you. Yeah. Okay, I do have a handout. It's this one. It's very simple. And for the audience and everyone else, I do have large versions of that. So I'm not just talking to the commissioners. I'll let you know. All right. Good evening, Chair Fowler and Planning Commissioners. Thank you so much. I want to echo all that. Okay. I'm Ken Eklund. I live at 37340 Moss Rock Drive in Benton County. Thank you, Ilya, Matthew, Zach, John, Annette, JP, and Rin for gifting me more time to speak. I want to speak first to a concern that you have, Chair Fowler, and try to give an answer that you tried to get from the applicant, I think in vain. You asked them, does an input of a limit of 930,000 tons a year of organic waste into the odor model validate that model? Does it make it work at mitigating the harms of that waste? Now, I'm just a guy with a computer and motivation to use it, but let me tell you how I break that down. The 930K limit helps but doesn't mitigate the odor harm, because a lot of odors come from organic waste, but by no means all of them. Plastics, for example, produce VOCs, volatile organic compounds, as they break down. And a lot of odors result from organic and inorganic waste interacting. And as Commissioner Lee established, approving the expansion would remove the cap for non-organic wastes. So then there could be a lot of inorganics for the organics to interact with. You could see yearly intake volumes of non-organic waste go up sharply since the sky is now the limit. And of course, since there's no limit to any waste that Republic self-identifies as not organic waste, you would likely see a sharp rise in intake of inherently stinky things, anything contaminated with chemicals, for example. A more important thing to consider is that the odor is landfill gas, and the odor consultant told you flat out that landfill gas generation is going to just keep going up and up through the year 2052. That's because it's an additive thing. You're not smelling just this year's garbage, but last year's and the year before that, and so on. If landfill gas is going up, then odors are going up. We're seeing this phenomenon at landfills across the country, where more and more waste goes to fewer and fewer landfills, and the additive effect means rapidly escalating odor impacts for the communities around those landfills. And there's some testimony in the record for you to read about that. In the case of the expansion, it will come online after the quarry has filled, and the quarry doesn't have a 930K limit. So it could have taken in a huge volume of organic trash, and we would be smelling that as the expansion would be going forward. But even more important than that, I would say, about the model is that it has other inputs, not just organic waste. You input gas collection efficiency, for example. We see the odor consultant has finally abandoned using an industry standard number as input, and now claims to have based it on the landfill's actual emissions, which I have to pause right there and question, why didn't they do that from the beginning? The thing about actual emissions is those are numbers that Republic generates, and they are suspect and sharply contested. I think the EPA served them a section 114 on exactly that question. How much landfill gas is leaking out of Coffin Butte? I, for one, have no faith in Republic's self-generated number. So that's my attempt at answering your odor model validation question. The answer is no for those three reasons at least. And then there's a fourth reason, which is this. If we could show everyone. So this is the graphic that I have showed you. Yes. So what are we looking at here? This is from a survey of Coffin Butte done by satellite by Carbon Mapper, a climate science nonprofit. Carbon Mapper just got a 2025 World Changing Idea Award from Fast Company for their methane data transparency innovations, i.e. for this, which is indeed a world-changing service. It's certainly made the odor modeling industry obsolete. Why model it when you can just look at it? Commissioners, there are people's houses in this plume. Some of those people are here in this room. So, hang on a second. I've gotten a little bit out of order. So what you're seeing here, this is Coffin Butte Landfill on April 28th of this year at 7:47 and 18 seconds in the evening. This is a plume of landfill gas at super emissions levels that extends for almost 2 miles from the back of the top of the landfill into homes along Highway 99W and across 99 into E.E. Wilson and then into more homes in Adair Village. I think it's fair to say that it's very difficult to reconcile the odor consultant's representation to you of odor travel around Coffin Butte only at nuisance level at our property border, I think is what they said, with this real world plot of landfill gas streaming out into the surrounding community. And remember, the plume you're seeing is landfill gas at super emissions levels. The odor plume is much bigger than this. Carbon Mapper can also quantify how much gas the landfill is leaking. They estimate this one is leaking 2.4 metric tons of landfill gas every hour, plus or minus 0.4 metric tons. I don't know what number the model used for actual emissions, but I'm guessing it's a fraction of this. This image plume is not an outlier. Carbon Mapper surveyed Coffin Butte 3 times in April and found it mega leaking each time. In fact, for about 2 years now, Carbon Mapper has never surveyed Coffin Butte landfill and found it not mega leaking. The bad news is their latest survey on May 30th found that Coffin Butte is now mega leaking from 2 different mega leaks at the same time. Things are visibly getting worse. Okay, guys, I'll let you go. Thank you so much. I hope, commissioners, that gives you some clarity into the odor model and its limitations as proof of Republic's claim of no serious interference due to odor. So what Carbon Mapper has done from the air, the EPA has done with boots on the ground, which leads us into my next TED Talk on compliance. So legally speaking, a burden of proof has 2 parts. The first is burden of production. That is, the burden party has to produce evidence to support their claims. Their burden of proof also is burden of persuasion. That is, the burden party must provide you with a narrative that convinces you that their evidence is valid and their claims are true. So they can't just dump documents on you and burden you to make sense of it all. They have to explain them. And really, they have to convince you. That's their burden of persuasion. So to jump back up to the odor study, the applicant has provided a new odor study, which is the latest in a long line of odor studies, under their burden of production. And they've made representations about it under their burden of persuasion. And you collectively had questions about their evidence, and maybe more now that you've heard more testimony and seen that landfill gas plume rolling into Adair Village. And so the question is the applicant's narrative about their odor study convincing to you? Okay, back to compliance, by which I mean Republic's representation of themselves as cooperative partners in environmental stewardship of the land, and the many questions that you have and the public has about that representation and the proof of that narrative. It's a key question because trying to get a non-cooperative party to adhere to 86 and counting conditions of approval is a hellscape. We've heard from Missy Ryan that we have no hard evidence, only anecdotal evidence of Republic's non-compliance with past conditions of approval. Well, anecdotal evidence is still evidence, as Attorney Kleinman has told you. But that's not really what we're looking for anyway. We're looking for Republic fulfilling its burden of production on this issue. We're looking for the list of past conditions of approval and Republic's documentation of fulfilling those conditions or otherwise dealing with them. Very simple and straightforward. But Republic has not done this simple and straightforward thing. As Commissioner Biscoe mentioned earlier, they didn't do it during BCTT either. So Republic has failed their burden of production on compliance. Let's imagine for a moment a different landfill operator, one that embodies Republic's claims of being environmental, neighborly, and cooperative. Let's call it ENC for short. ENC would have no problem supplying you documentation about past conditions of approval because they would have been keeping track of them. So Republic seems to diverge here from being environmental, neighborly, and cooperative. Let's look for other instances where Republic's attitude towards compliance has been put to the test. Yesterday, Brett Davis of Republic mentioned that the landfill is safer now fire-wise because the open flares it used to have been replaced with an enclosed flare. What he didn't mention is that if Republic had actually complied with DEQ environmental regulations, the enclosed flare would already have been installed and at least one of the grass fires would never have happened. Republic learned they had to install and certify an enclosed flare in September 2021. They didn't actually comply with that regulation until November of 2024, over 3 years later and a year and a half after deadline, and only after DEQ issued them a Class 1 notice of violation. And to me, this is the kicker about that story. The grass fire damaged the flare equipment. So Republic asked for an extension of complying with their Class 1 violation due to the fire that their Class 1 violation had caused. Commissioners, you just heard testimony by Erin Bradley, who is she and her family are downwind from that fire. She runs a horse therapy nonprofit, as you heard. So when she saw that fire starting, she had to load up her horses and otherwise prepare to evacuate. Luckily, Adair Rural got the call and arrived on scene and put out that fire. All because of Republic's lack of compliance with DEQ regulations. Something they should have disclosed to you, but didn't. And a pretty big crack in their environmental, neighborly, and cooperative narrative. Let's look at another instance where Republic's attitude towards compliance has been put to the test. Let's look at Coffin Butte's compliance history with the EPA. Republic's burden of production. If you ask the EPA, and I have, Republic should have provided you with at least 3 key documents. They should have handed over the 2022 EPA inspection report, the follow-up 2024 EPA inspection report, and the 2025 Clean Air Act Section 114 information request, EPA enforcement's legal notice in January. They've given you none of those. So Republic has clearly failed their burden of production. They've made various representations to you about those EPA actions, but they have not provided you with the documents to prove those representations. Republic's burden of persuasion. Well, you tell me, what narrative has Republic told you about the EPA actions? I think it's nothing to see here. Let's move along. If you ask the EPA, and we have, they will tell you that Coffin Butte is an active enforcement situation. The VNEX lawyer says the same. I don't think Republic has admitted even to that. Has Republic convinced you that there's nothing to see here? Let's move along. I can give you a narrative about the dump's recent compliance history with the EPA, and you can decide for yourself if it clicks. I've already documented every step. Just search the public record for the word explainer. According to Senator Jeff Merkley, his staff received a lot of constituent complaints about the dump in 2021. So he put pressure on the EPA to look into it, and the EPA made an announced inspection that July in 2022 and found 61 leaks at reportable levels and higher, including 4 at explosive levels. While the EPA inspector, Daniel Hines, was finding all these methane leaks, Phil Caruso, environmental technician for Republic Services, was with him. Caruso didn't dispute the findings, but said he would not have checked many of the leak locations, that he would have spent less time monitoring, and otherwise would have carried out the inspection using interpretations of the testing protocol that would have enabled him to not find the leaks and therefore not have to report them. So that's in the report, which you were not given. Time passes. It's 2024. Republic has started up this application to expand the landfill. They set the wheels in motion, and then EPA made their unannounced inspection in June of last year. And it's another embarrassment. And then that unannounced inspection and its findings triggers the Section 114 legal action, which is basically an audit of all the dump's environmental records. At which point, Republic had a choice. They could have come clean with you. They could have said, here's what happened, here's what's happening, here are the reports, let's talk about this. That's what their burden of proof obligates them to do. Instead, Republic chose to pretend as much as possible that there's nothing to see here, that this bad compliance history with the EPA should just be ignored. They dealt themselves a bad hand, and now they're trying to bluff it out. Republic often asserts that environmental regulation is something DEQ and EPA do, not the county. But this isn't regulation. This is information about regulation. You on the Planning Commission require the history of the regulatory process so you can better understand what is likely to happen in the real world if that process were to expand along with the landfill area. This information is directly relevant to your criteria and deliberations. So my dear overworked planning commissioners, you can sit back and take a breath. The hard part is over. Your decision has been made for you, and Republic has made it. This is a matter of key importance to this application, and Republic has totally whiffed it. Good compliance is something they need to prove, and they have not. In fact, by their silence and evasions, they've created strong evidence of the opposite. Without this proof, conditions of approval are a non-starter. Game over. You say. It seems unlikely that some old guy with a ponytail and overalls can torpedo the entire Republic application. But it's not me. I'm just the messenger. As I told you, what happened was the public outroar over the last expansion application activated our congresspeople who pressured the EPA to inspect, and that went poorly for Republic, as detailed in the report that Republic did not give you. So the EPA followed up with another unannounced inspection, which went even more poorly for Republic, as detailed in the second report that Republic did not give you, which escalated into the Section 114 legal action, which Republic did not tell anybody about. But the county's Disposal Site Advisory Committee dug it up with a Freedom of Information Act request. And this legal action, which Republic definitely has not showed you, got passed along to Benton County's Environment and Natural Resources Advisory Committee, NRAC, who, as you know, are charged to advise you on this application. And NRAC cited the EPA's legal action as a key element in their recommendation to you to deny Republic's application. Like I said, I'm just the messenger. It took a village. Now, the escalation of the EPA's investigation into Republic's compliance history is one thing, one bad thing. But my key point here is that what Republic chose to do with those developments is entirely another. They chose to keep them from you. So, commissioners, I think you can realize what this means for your deliberations and your decision. An approval with conditions would essentially be telling the public, yes, I know for sure that Republic is bad about complying because they refuse to comply with our requirements to be truthful about compliance. But I feel sure that Republic will be honest and forthright with you going forward. After all, you have a piece of paper with conditions of approval written on it. Maybe it's just me, but I feel that would be a low thing for you to do to the public. As Attorney Kleinman laid out for you, legally this has to be feasible. It has to be, quote, possible, likely, and reasonably certain to succeed. You have zero proof of that. All the proof before you, especially Republic's evasion, indicates the opposite. At the very least, it signals strongly that trying to enforce the conditions of approval is going to be an undue burden on public facilities and services. As I said, a hellscape. To be a little more dispassionate about it, given that Republic knowingly kept important information about their noncompliance from you, it seems you cannot rely on their compliance for any part of any approval. So you would have to find that the proposed use would not seriously interfere with uses on adjacent property or with the character of the area, nor impose an undue burden on any public facilities or services, etc., even if none of the conditions of approval are met. Because if you look at the proposed conditions of approval, all of them depend on Republic divulging information about landfill operations, not hiding that information at the first sign of trouble. Because that's the issue here, trouble. I'm sure the Republic guys feel that I'm being very unfair. They have tons of successful compliance they can point to and say, see this here? We complied. See that? We complied. And this and this and this and this. We complied with all of those. And that's all very true. But the core issue is, especially with the conditions of approval, what happens when there's trouble? When the test wells show a severe impact to groundwater, or when those smellometers start lighting up like crazy? What happens then? I think the answer to that is pretty clear. Nothing to see here. Please move along. All the evidence points to this. Respectfully, I don't think you could or should make any finding that supports a condition of approval, especially because I think we all know this situation is just going to escalate. Republic certainly thinks so. They've brought a veteran environmental manager, Paul Koster, to Coffin Butte. Paul is fresh from Republic's Sunshine Canyon landfill, which last year received over 2,000 complaints and 65 notices of violations. But Paul's skills are wasted there now, as the state has finally stepped in with an abatement order, and so he's here. I've put an LA Public article about Sunshine Canyon into the record. Commissioners, be sure to give it a read. It's not hard to find. The headline is, "A Stinky Landfill Torments Its Neighbors in the Northern Valley." I have to point something out. I'm getting close to the end. I have to point something out. If we were dealing with a landfill with a good compliance record, they would have sent their EPA inspection report to you. And a good landfill would only have that one inspection. It wouldn't have a follow-up unannounced EPA inspection by an air enforcement officer like Coffin Butte had. And a good landfill wouldn't have had that second inspection escalate into a Clean Air Act legal enforcement action. But Coffin Butte did, which I believe is unique for all comparable landfills in Oregon, Washington, and Idaho, based upon my results so far from my FOIA request about it. So far, it looks like Coffin Butte is the only municipal landfill in EPA Region 10 to have gotten a Section 114 in the past 3 years or more. If we were dealing with a good landfill, a cooperative landfill, they could prove it to your satisfaction. They would have proved it to your satisfaction. But we're not, and they didn't, and that's a serious thing. So please take it seriously. Deny this application.
Thank you.
Questions?
Questions? Thank you, Mr. Eklund. Next on our list, number 35, Mr. Hutchinson. Oh, Ms. Whitcomb, are you next? Let me see. Not quite. But if he has ceded time to you, you are next. So thank you. I apologize for that.
Which I am assured you have in front of you.
We indeed do.
Marvelous. Am I close to the mic?
Yes, perfect.
All right. So I have 12. Yep, I've got 12 minutes. All right. My name is Nancy Whitcomb. I am an architect. I've been an architect since 1991. I'm a lead AP professional, and I was heavily involved with land use during my professional career, which is now thankfully over. I have done a really deep dive into the history of the landfill, and I have to say, the history of the landfill is one that is marked by repeated attempts on the part of the county to ensure that the landfill did not adversely impact surrounding properties. It is a history of repeated failure for this goal. County Council spoke to this last night in reference to adjudicating non-compliance, but the record of property ownership around the landfill tells its own story. And if you turn the page, I've done a number of little diagrams. Since 1985, the landfill has increased ownership of acreage around the landfill by 500 acres. It is now more than twice the size of Adair Village. Each one of these acres has been acquired from a property owner who felt that he or she had no choice but to give up on his property and sell out to the landfill. And we've heard testimony on this tonight. The little diagram I did has intriguing little blue boxes that are hard to read, and you can read them in your spare time. I'm not going to go into that. Your ample spare time, I should say. Why talk about what has happened in the past? To convey the probable scale of future adverse impacts. We're not talking about a headache. We're not talking about a migraine, although those are not great. We are talking about having to leave your home and not being able to sell it. That's what we're talking about. That is a significant adverse impact. It has already happened. If this is approved, it will happen more to the people who have testified tonight. It is not normal for one land use to so adversely impact all surrounding land uses that it engulfs and assimilates them. That is the plot of a horror movie, not a land use action. What does it mean that this has happened here? It means that the zoning has failed. The landfill claims that it uses some of the lands that it owns for zoned uses. It claims that it farms some of the EFU lands. But that's really symbolic Potemkin farming. A $16 billion company, $16 billion of gross revenues, has no need for $1,000 a year from a farmer who farms hay on the land. It's probably actually a real liability problem. But there is a real purpose behind them owning that land. The real purpose of that land is to rezone it at some point in the future and turn it into more landfill. How do we know this? There is an email that's on the next page. It's reproduced as we received it after our public records request. Julie Jackson to Vance Croney, we have many acres that could hold waste and that will likely be a future discussion with the county. Julie. Vance Croney to Julie Jackson, October 14th. Republic has many acres of EFU zoned land that certainly can be used for additional cells, but would require rezoning. I think probably they wouldn't. They'd probably only require a conditional use permit. Let's briefly talk about what a conditional use is. A conditional use is one that may have adverse impacts, blah, blah, blah. So if you apply for a conditional use permit, you have to prove one of two things. You either have to demonstrate that your proposed use will not have adverse impacts, or you have to acknowledge that it will have adverse impacts, but that portions of your proposal are sufficient to eliminate those impacts, to render them inconsequential. For the application before you, the county and the applicant agree that there are adverse impacts that will significantly impact adjacent uses if they are unmitigated. So unless each and every one of those conditions is strictly adhered to, other property owners will be impacted. They'll be impacted significantly, and the impact will be adverse. The applicant agrees to that. The county agrees to that. Staff has heroically crafted 84 requirements to keep this proposal from significantly harming abutting, adjacent, and other uses within the 90 square mile area. But unless the applicant voluntarily complies, or unless the county has the means, the sophistication, and the appetite to enforce these conditions, they are meaningless. Let's address whether the applicant will voluntarily comply. The applicant has never been more motivated to reduce odors, for example, than in the past 4 years, awaiting resubmittal of this application after the previous application was denied on the basis of odor. The applicant knew what would help odor: stop taking sewage sludge and rotting animal carcasses and construction debris, which does produce significant amounts of odor, especially when drywall decomposes. The applicant could have voluntarily reduced total garbage intake. But has the applicant done any of this? No. 4 years after the applicant could have taken significant actions to reduce odors, odors are in fact worse than ever. So what action has the applicant taken to reduce odors? Nothing. Can the applicant comply voluntarily? Is it even possible to reduce these odors so that they aren't significantly adverse impacts on adjacent properties? Well, we've heard about Sunshine Landfill. They've been in litigation for 9 years about odors, and they got 2,137 complaints in the most recent reporting. So the applicant has not demonstrated a record of voluntarily trying to reduce odors that are impactful. We have some doubts that the applicant even can achieve reduction. So the other question is, will Benton County enforce compliance? We love Benton County. We love you guys. We love Benton County staff. But let's face it, Benton County is a small county with a small staff, budget problems, and the applicant is a $16 billion Fortune 500 company with a lot of lawyers. A lot of them are right here. Benton County knows that the landfill is hurting the people that live here. They heard about it in excruciating detail in 2021. The county heard that people were afraid the landfill was making them sick, and that we're having quality of life impacts, and that they hated the eyesore that the landfill had become. What action could the county have taken in response? Well, in response to concerns that the landfill was making them sick, the county could have reached out to the Oregon Health Authority to investigate cancer clusters. Quality of life impacts due to odors. The county could have reached out to DEQ and asked for a follow-up on nuisance complaints with enforcement action and civil penalties. The eyesore. The county could have asked the applicant to apply final cover to close cells fronting the highway, revegetate, and plant some damn trees already, as is required by the 1983 zoning and the 1965 Highway Beautification Act, a federal law. What did Benton County do? Benton County did nothing. Just to be clear, we're not talking about you guys. We're talking about our elected representatives, the ones that have their hands on the money. So let's talk about this organic waste intake limit. Let's not even get into the definition of organic, or that the county's odor consultant believes that construction and demolition debris doesn't cause odors. What happens if the applicant exceeds the organic waste intake limit? Will the applicant even know? If the applicant knows, will the applicant tell? If the applicant knows and the applicant tells, will the county do anything about it? Does the county have the appetite to enforce this limit? Or will the county do the same thing it did in 2017, 2018, and 2019, when the applicant exceeded contractual volume limits by 150,000 tons per year minimum, and the county did nothing? We've seen this movie before. We know how it ends. Don't waste your time trying to craft the perfect language for conditions of approval. That's been tried before and it has never worked. It will go down the memory hole like everything else. And if you want to, you can ask me about the 2003 baseline study. That's a fun one. Yesterday, Chair Fowler, you asked about confirming the model. I am so glad you asked about that. Starting at the timestamp on the 1 hour and 18-minute point in the video, Ellery Howard of Mall Foster addressed this issue by referring to the 2023 intake volumes cited. He mentioned that they used from the applicant's actual emissions and the applicant's model. And the conclusion was that using those inputs, the conclusion was that on the perimeter of the landfill property, odors were sometimes detectable by some people, but did not rise to a nuisance level. So I'd like you to turn to page 8, please. Coincidentally, this is what happened in 2023. That's when a vineyard owner couldn't sell his vineyard because of landfill odors that sickened a potential buyer. This happened in April of 2023, during the time that the applicant's odor consultant says that odors were possibly detectable by very sensitive noses on the perimeter of the landfill. In 2 pages, you can see where this vineyard is located. This vineyard is located 3.84 miles as the crow flies to the northwest of the landfill. Here are quotes from the Polk County Itemizer Observer from March 2nd, 2023. The day they decided, they being the buyers, decided to quit was the day a south wind blew up from the dump. He, the buyer, was allergic to it and got violent migraines. Tom, that was the seller, said the buyers left behind a chunk of money after pulling out of the deal, so they're okay for now. It took them an additional year to get that property under contract. I'm sure they had to disclose the odor problems. I'd like to finish by saying, believe that Benton County, when it says that this application will result in adverse impacts, that is true. More people will finally give up and move away. Residents' wells and ponds may dry up. They will pick litter out of their fields and hope they get to it before their livestock does. More people will decide to sell out to the landfill. The Phillips home, this little sliver of dark blue, that may become uninhabitable due to odor and noise. This application needs to be denied just to protect that elderly couple. Do not believe that the conditions of approval will be enforced. The applicant has too many resources, too many lawyers, and too much money for the county to enforce anything the applicant doesn't want enforced. And don't believe the applicant's models. They are predictive, but what they predict is fiction, not fact.
Thank you, Ms. Whitcomb. Let's see, Ms. Higgins. Okay, thank you. Let's see, Mr. Joel Weinstein. Oh, I see that, but Mr. Yeager indicated that it was for ceding time to somebody else, perhaps? Oh, thank you. I'm confused here on the list. Okay, moving down the list, number 53, Mr. Orton. Okay, he's participating remotely.
I'm here. Can you hear me?
We can hear you, yes.
Okay, are we ready to start?
Please begin.
Ladies and gentlemen, my name is Robert Orton. I live at 2435 Salem Avenue, Southeast, Albany, Oregon. I'm the whistleblower from Coffin Butte Landfill. I know where you guys are. I know the pressure you're under. And I know ultimately the fear. These are all things I went through as a whistleblower trying to expose these things. I've dealt with the Republic Service's shuck and jive. I've dealt with their lies as an employee. The fact that they are not forthcoming about anything, The fact that they have not answered for anything is stunning. And the fact that this seems to be missed on the committee is even more stunning. The notion of putting out ethics that they have to follow in order to get this, if you told them they needed to sacrifice puppies and kittens, they would be out in the parking lot sacrificing puppies and kittens to get this. When you threw out those conditions, Republic Services' heart leapt. If you look at the enforcement, they managed to get a $700 fine from DEQ. We as employees screamed for months at DEQ. Then when they finally came out, Republic lied to them. And it can be demonstrated that Republic lied to them. And they caught a $700 fine. Fixing the things we complained about would have cost them more than $700. It is a math problem for Republic. That's what this comes down to. They care not about the environment. They care not about what the effect's doing. What you have to understand is this is their most profitable site. They will do anything to maintain control of that site. Now, agreeing to what you put down is great and one thing, and I'm sure that Ken can't wait to get out the pen and sign that. The problem is as has been pointed out to you, total lack of enforceability, total lack of consequences should they violate. Now, I know the pressure you're under, and I know that, hey, $1 million coming in, boy, you'd all like to have your name on that. Coming in for the county, $1 million. Certainly, the environment, the people you've seen before you, the community at large has got to be worth that $1 million. Looking out for your constituents, not abdicating your responsibilities, not looking for some Nuremberg defense down the road where, oh, well, they told us it was all okay, so we have to embrace that.
Mr. Orton, I believe we have your point, and I appreciate your input. Thank you.
Okay, I've still got 3 minutes on the clock, sir.
If you are going to use your time, I would ask that your narrative be more respectful.
More respectful of who, sir? The community at large? The people that have something to risk here, something to lose? Those people, sir?
I mean, for all participants involved. So you may use your.
I was trying to be sympathetic, sir, to the position that you're in and what you're feeling, because what I did stepping up destroyed my life. I'm still seeing a counselor twice a week there in town for the trauma that I went through there. I am empathizing with you guys and the difficulty that you're under. I know you don't want to hear this. You came up with conditional use numbers and Republic's going to sign off to them and you can wash your hands and say you did a good job. But that's not how it works in the real world. You can run down there and smell for yourself what's going on. Don't abdicate that to somebody off-site running a model. Go down there and look. Go down and look and see what people are talking about. Don't see what Republic Services shows you, because Republic Services shows you a carefully topped photo or this or that, but they never present the whole picture, not to you, not to anyone. And again, regarding these EPA reports, I would like to point out that in an email addressed to Brett Davis through the company email system back in January, I believe it was, of 2023, Brett Davis indicated that they had followed all of the recommendations of the EPA, that it was safe to work out there, that there were no methane leaks, because again, they addressed all of the issues laid out by the EPA. But we know now the EPA laid out no issues. We know now that Brett Davis lied. We know that their environmental officer that was out there last time and lied to the EPA. Their environmental officer lied to the EPA. And for some reason, people seem to think that they would give them the truth. What I'm saying is you got to look deeper. What I'm saying is if you just want to look at the fluff that they're giving you, then this entire thing was nothing more than a bogus.
Mr. Orton, again, we've offered the time. but we're violating the rules of respectful discourse amongst this proceeding. This proceeding is intended to introduce new evidence. I believe we've gotten your point. I also believe you're reiterating some points you made in May. We appreciate those points. And so thank you for your testimony. Moving next to what I believe is our final public comment is Ms. Stearns, number 54. Oh, okay. We are then just looking to make sure I didn't overlook anyone on our list. So that concludes public input. And so we are at the question as to whether there is a request to extend the record. And I have this document. Ms. Ryan, is that a request?
Chair, could we take a short recess before the applicant's rebuttal?
Yes, we
Also,
can.
and maybe you and I can connect. Okay.
Let's do that. It's about time for a brief break. We'll huddle with council and return with the applicant's presentation. So let's take no more than 8 minutes. 9:40, please. We are back in session. And we have concluded the public testimony portion, and we always afford the applicant some time for rebuttal in the same hearing. Does the applicant wish to use some time to rebut the testimony?
It's not even taking me 4 days to learn how to use this. So, Mr. Chair, in the interest of getting you home to your by the time of your bedtime, I'm going to keep it short tonight. There's a couple of quick points I want to hit, but there's a lot of new arguments that came in tonight that we will address in our final rebuttal, so everybody in the room can go home and go to bed. So the first one, I want to focus on conditions of approval. Well, that was a lot of discussion about that tonight. And the first comment I wanted to address is that, and we actually addressed this in our June 6th response to Mr. Kleinman's testimony, but we disagree with the representation that we have been continuously violating all of the conditions of approval since day one. I was on that same committee in BCTT with Mark Yeager, and the fact is the problem with particularly the 74 and 83 decisions up to about the mid-90s decisions is the record was incomplete. So there was not a way to prove one way or the other if conditions had been complied with. There were some questions about conditions, whether the conditions were actually legally imposed in 1983. There was questions about whether the interpretation of the conditions, and that of course would affect whether we violated them. So there was a legit, the citizens members of that committee produced that report, that was their opinion, but there was contrary evidence about that. And so we have been trying to, we'd just like to get that on the record. Secondarily, Republic acquired the landfill in 2008. Our records were similarly bad from that era, so it was difficult for us to try to go back and refute it. So it's one of those things where it's a much more complicated question than just that we violated the conditions. I wanted to get it on the record. The next thing I wanted to talk about is enforcement of conditions. And the concern that the county will not enforce them or cannot enforce them. I have been a municipal lawyer for most of my 40-year career, and the county's practice of enforcement through response to complaints is the typical method of code enforcement. So that's not a failure to send out the zoning police. Most local governments don't have zoning police, and it is a problem with enforcement, relying on complaint-based enforcement, but it does work, and a lot of local governments use that. So that's not a, that's whether or not the county wants to go with a full code enforcement staff and affirmatively go out and look at conditions, that's one thing. But it can be done. And I'm going to give you a specific example from my career. There's a case called Mingo versus Morrow County, which I was involved in about 15 years ago. That case is cited again in my response to Mr. Kleinman. But that case involved, my client was Invenergy. They were a wind farm company, and they had gotten a conditional use permit from Morrow County to construct a wind farm. And Morrow County imposed a condition requiring the wind farm to comply with the DEQ noise standard, which is one of the conditions, of course, that is in the county's recommended conditions. And a neighbor filed a complaint that my client, the wind farm, was in fact violating that condition at several residences. And there was a lot of investigation of that. And the county ended up instituting a process to revoke the client's conditional use permit. And that is an option that the county has under the current county code. That, of course, is like a bet the company kind of enforcement action, because if the county did revoke that permit, that would cause the wind farm energy and Coffin Butte to violate its DEQ permit and would result essentially in shutting the operation down. So it was a serious violation. And in fact, the evidence showed that that my client was violating the DEQ noise standard at several close residences. There was a whole bunch of questions like we've had here about how you calculate the noise standard, and it went through the local process twice. It went up to LUBA twice, and came back down, and eventually it was settled by a revised condition of approval that required my client to, in certain wind conditions, to turn off their turbines in the area close to the house, which knocked the level of sound down below the threshold. And so that's an example. And this is, we're talking Morrow County here, population, I think 10,000. So in terms, so the Benton County is an economic powerhouse in comparison to that. So it can be done, and that enforcement is significant. And I just want to, just want to get that out there, that is a very serious remedy, and those teeth are very sharp. And then finally, the issue of the federal enforcement action. So, it's, as everybody I think in the room would acknowledge, this is a complicated business. It's highly regulated. There's a lot of environmental regulations that has to comply with. We have to go through this process, and then we have the whole DEQ process, and we have compliance with the EPA. So, I would, one way you could couch the 114 proceeding is that's the feds doing their job. And our response to that is to try to comply and bring us into compliance. And there hasn't been certainly an enforcement penalty could be assessed in that process, but there's still an audit phase, as Nancy mentioned. So I think that in fact, that is an example of the various regulatory authorities that are over the landfill, all of which the landfill has to comply with in order to continue its operation. And our suggestion of some of those conditions and willingness to accept some of those conditions that we had to swallow hard to do is an example of our efforts in good faith to try to ensure that any expansion does not have significant adverse impacts. And so I think with that, I will cease here and let us all go home and go to bed.
Thank you very much, Mr. Condit. Prior to closing, I will ask if there is a request to leave the record open and first look to the applicant if they would like to make such a request.
Surprisingly, I would. We would. We were hoping not to have to, but a lot of new information came in, some of which contains new evidence that we would need to have an opportunity to review and have the chance to respond to. So we would formally request that the record be left open for 7 days to permit response to new evidence submitted tonight at the hearing.
Thank you. The applicant requested that the record be left open to submit additional written evidence, arguments, or testimony for the purpose of responding to the new written evidence submitted at this continued hearing, and pursuant to ORS 197.797(6)(b, because such a request has been made and because the commission has determined that the new written evidence submitted this evening is in fact new, the record is left open until July 16th, 2025 at 4 p.m. for the limited purpose of submitting additional written evidence, arguments, or testimony for the purpose of responding to the new written evidence that was submitted at this hearing. Responsive written evidence may be submitted through email to public comment at bentoncountyoregon.gov prior to July 16th, 2025 at 5 p.m., or through hand delivery to the Community Development Department prior to July 16th, 2025 at 5 p.m. Written submissions during the open record period that are not limited to responding to this new written evidence submitted at this hearing may not be considered by the commission. Let me first look to Ms. Ryan to understand whether, do we need a motion from the commission, or is the statute in and of itself sufficient to extend it? Thank you. So this does not require a motion of the commission. I do want to comment for the public, this was a bit of word salad, but to try and put it into perspective, we've already held the record open prior, and so now we're holding the record open for a very limited purpose, and it's to be responsive to just new written evidence submitted this evening. And so to help understand what that new evidence is, staff will place that new evidence in a folder in Muni Docs that will have some descriptive name, which is like new evidence from this evening or something like that. It is only that evidence that can be responded to. And that's what it means by we may not consider other things that come in that are outside of being responsive to that folder. So I hope that's clear. This is kind of it's new for me as well. This portion of the law does not get exercised very often. I've not seen it, and so that's why we're kind of bumbling through this just a little bit. So that record will be held open until July 16th of 2025, as I described. Further, the applicant is allowed until July 22nd at 12 noon to submit final written argument in support of the application. The applicant's final submittal shall be considered a part of the record, but shall not include any new evidence. Let's see. Mr. Kleiman, you have your hand up. Do you have a procedural question?
I do.
Please ask.
Get my video open. Here we go. Yes, Mr. Chair, thank you. This has been a two-night hearing. And as I said, we all appreciate the endurance capacity of this commission. But it's not a matter of tonight and last night, and the applicant gets a chance to respond to new evidence tonight. All parties should be entitled to respond to new evidence that was delivered during this continued hearing on July 8 and 9.
And if I did not read that correctly, that's my mistake.
Chair Fowler, this is Commissioner Biscoe with also a procedural question. I'm not sure. So I've been hand raising and then now they've given me opportunity to nod. Can I ask that question procedurally speaking?
In just a moment,
Okay.
Commissioner Biscoe, Council Ryan is going to address the question on the table.
Yes, this is a limited open record period. We have a 150-day deadline that is looming, that the county has built in time for a potential appeal to the Board of Commissioners, which also takes time. ORS 197-7976B prescribes this procedure. This open record period is exactly as stated in ORS 19776B, and it is for the limited purpose of responding to new written evidence submitted at these two hearings. So if it did not come in writing, there is no response right, because ultimately this has to end and we have to move towards calling the question.
That makes perfect sense.
So allow me to,
Did you just agree with
read the paragraph again, just because it is, we don't use this very often. I'll read this paragraph again. So pursuant to ORS 197.797 paren 6 paren B, because a request has been made and because the commission has determined that new written evidence was submitted at the continued public hearings of July 8th and July 9th, the record is left open until July 16, 2025 at 4 p.m. for the limited purpose of submitting additional written evidence, arguments, or testimony for the purpose of responding to that new written evidence that was submitted on July 8 and July 9. And so I believe, Mr. Kleiman, does that address and comport with your question?
It does. Thank you, Chair.
Okay. Commissioner Biscoe, you have a question.
Yes, thank you, Chair Fowler. So that clarifies my question on the written evidence only that we're responding to. What I'm not clear of and what does not appear to be stated in this statute, or it appears to be silent on, is the potential response to the new written evidence. Is it limited to the applicant only or limited to anyone who might wish to respond to that new written evidence?
There's no response period. That is the conclusion of the evidentiary portion of the hearing, will be the 7-day open record period.
So my question still is, this open record period, the opportunity to respond then goes to who? Is it applicant, or maybe I'm just not understanding? I'm hearing
anyone,
that we have anyone.
And so again,
anyone can respond.
Thank you.
During that 7-day open record period.
Very good.
And we will, staff will, place that new written evidence in a separate folder to make it clearer to what the public and the applicant are responding.
And then to clarify the July 22nd noon deadline for the applicant to respond, I believe is what I understood you to say. Is there a limit to that written response? As in, at noon, are we going to get many pages? I'm not sure what that response looks like, or what kind of surprises might we be in for potentially in that rebuttal?
It is the applicant's final argument. So it's the opportunity that the applicant has by statute to present their final case. It cannot include new evidence. It is for argument only. And
The
I
timeline, oh, excuse me. Go
I would
ahead.
anticipate that it will be a reasonable length.
Okay. And the timeline of which the commission then will have access to that before our deliberations, the evening of the 22nd?
So that will be 6 hours.
Yes.
I do want to express my appreciation for the flexibility that the applicant is showing to get us this this final written argument ahead of the statutory requirement in order to give us some time to have it prior to our deliberations. And again, those deliberations are scheduled to make the time limit. We've expanded as much as we possibly can to incorporate the inclusion of public testimony, of all written evidence, which constrains us on the back end to make our decision. So unfortunately, that's the time. We will have deliberations on July 22nd at 6 p.m. And for the public, if you haven't participated in a planning commission process before, deliberations are a structured discussion just amongst the planning commission. There is no public comment period. We don't ask any more questions of the applicant. We don't ask any more questions of the staff, with a very limited exception to clarify, because they have to write up our decision. But there is no new evidence. We don't ask questions. You would just be observing a structured conversation amongst the 8 of us planning commissioners. Yes.
About a different date than the one that you repeated. And so I would like to ask Ms. Ryan, what is the end of the 150-day date that you have looming?
September 26th.
So with that, this
the whole evidence, where you can access it. Is it going to be online, or is it going to be?
It will be, yes. So that folder that I described is on Muni Docs, which is available online. And I don't know yet what the title of that folder will be, but staff will make it obvious that it is the new written evidence. Ms. Kwiatkowski.
Mark, new evidence from the July 8th and July 9th, 2025 public hearings.
Thank you very much. That is very helpful.
Make an announcement to
Thank you all. I see some people yawning. I'm about to yawn. This public hearing is recessed until Tuesday, July 22nd, 2025 at 6 p.m. in this hearing room, at which time the commission will deliberate on whether to approve or deny the application. And again, no public testimony will be taken on July 22nd. Thank you and good night.